At the beginning of the proceeding, the matter is mentioned to be urgent. इसके बाद लिख लेता. At the beginning of the proceeding, matter is mentioned to be urgent. Earlier, the matter was extensively heard on 30.01.2026. Para. To grant further opportunity, matters shall be listed in the today's. Matters shall be listed in the. Keve chahunଛନ୍ତି sir? Matters shall be listed in the week commencing 9/3/2026. Yes, please. Next.
Obliged.
Test to 10 to 22.
Item 18, may I please, Lordship?
Yes, please.
Item 18, the brief is transferred to us. We're filing a new wakalatnama, Your Lordship.
18 simply adjourn कर देला होता है.
Wakalatnama.
Register चाहूँगी ताले out of turn नहीं पड़ेगा. You have to wait for your turn.
Or 18.
Yes. Or you request any of your friends who can mention that.
And if it is adjourned also, Your Lordship, but the power should be deleted for Mr. Balaram Naik and...
That what you are saying, I have to take up your matter and pass an order. And no priority.
Obliged.
Please.
I'll wait for them.
It's up to you. You can say, because there is nothing to be argued. So you can request any of your friends. Colleagues. Anyone can mention.
Pardon, my lord. Item number 19 permitted to be withdrawn.
Can you find your memo, sir? What's your name, sir?
My lord, Dakshesh Darshan Naik on behalf of Sunil Kumar Panda.
Dakshit Darshan.
Dakshesh Darshan.
Dakshesh.
Yes.
Spelling, sir? D-A-K-S-H?
Y-E-S-H.
D-A-K-Y?
D-A-K-S-H-Y-E-S-H.
Y-E-S. Dakshesh Darshan. Right. So, Mr. Panda has signed the memo?
Yes, ma'am.
So, kindly give it the memo and mention the serial number. Yes, next, please.
Obliged, ma'am.
Test 3, 23 to.
My lord, item 11, my lord.
11, sir. कौन चाहते हैं?
My lord, for transfer of the proceeding from Judge Family Court.
अरे आपण एबी कोण out of turn?
My lord.
Out of turn नहीं है मैंने. आपण असले बोली मैं I'll start taking up your matter. Today, Mr. Naik was mentioning. I cannot take up your matter out of turn.
No, but it is in list, man.
आपण चाहूँगे कौन sir?
To transfer the matter from.
You are arguing on merit, sir. The list is not. List sir is yet to be called.
Sorry, sir.
तारीख पे तारीख चल रहा है अभी. तारीख लेना चाहते हैं तो अभी ले लीजिए. वो भी देते रहते हैं तारीख पे तारीख. देते कौन है? किसको बुलाया जाता है कि किसके नाम से हो जाता है कि तारीख देते हैं. ठीक. बट ये अच्छा है कि आप मतलब you are eager to argue the matter. That's a good thing. Yes, Mr. Bahanta.
Item 30, Your Lordship.
Yes, please.
I am for the opposite party. I have to file objection.
Please inform the other side. What
already,
I filed about 3:30 days ago.
Already I will be informed and I have taken.
For that reason only they vehemently object. So after they finish argument, सकाळे मते कहले नहीं. Basically the matter is to be adjourned.
नहीं काली रात्रि
So they argue for 15 minutes for nothing because I can't do anything.
नहीं काली रात्रि को था
रात्रि कथा पढ़ेंगे. I am telling you about the sequence of events.
man
30 टा date consume. 23rd March कोचुंगी.
obliged.
Yes.
Test 4, 31 to 35.
Yes, please. Call the list.
Item 4 में permitted to.
तो ऊपर नंबर टा पकई देबे. 4 आपन को पावर सर अछि नित्यानंद देवरी. Right sir. Right. Total से तो body rate ना. The order will be passed. Yes.
My lord, WPC number 8139 of 2020.
Sir, listing, Mr. Mahanti, Padmalochan Mahanti at Balasur.
Listing, mention.
Give your memo.
Memo had been submitted yesterday. I am submitting another memo.
No. If you have submitted, that is enough, but you can't decide the date. It will come in the, it will be press, then orders, then admission, serially.
My lord.
So you are mentioning a fresh matter or after notice?
After notice.
After notice, it will be towards the bottom. Which year? Which year matter?
Matter 2025 8139, but I submitted IA on that is 22nd August 2025, my lord.
IA seeking what direction?
I have submitted my stand on this case from the opposite party. From opposite party, I am appearing for opposite party.
Sir, that I have understood, sir. Why you file the IA? What is the prayer in the IA? No idea. Okay.
One.
Get an idea. Give a date. We commencing 30 दिन. अपन number टा उतरे कोई भी.
My lord. Chapter 8139 of 2025, IA number 106 of 2025.
Okay, voice टा crack ही जाऊँगी. आप टी आस्ते कोई भी.
8139 of 2025.
8139 WPC.
WPC.
WPC 8139 of 2025. सेठी जे अचंती असिस्टेंट एसओ तांको कोन तो पठेई देबे मेमो.
Miller.
ये अचंती सेठी मेमो केमती फाइलिंग होची सेठी?
Achanti.
How the memo is filed? Yes, gentlemen.
Sir, online memo होची sir पहले.
Acha. You get properly dressed. I think all of you have been provided with a jacket with High Court insignia. So always dress properly. Okay, thank you.
Obliged.
से मेमो आपने लिखियो किस दिन ना केमती लिखियो पर केमती पोस्टिंग केमती होची सेटा मु बुझी पारु. एसो पड़ेले
Date cut for 20 today date.
सेटा आपण पठौछनी केमती डेटा का पठे का पाकु पठौछन. आपण पठे देबे रजिस्ट्री को.
सर एक्चुअली आम एठू ऑनलाइन फाइल करछु एडवोकेट जो डेट को
फाइल करछनी सेटा मु कोनी आपण पठौछनी हाई कोर्ट रजिस्ट्री केमती आके. हाउ द हाई कोर्ट रजिस्ट्री गेट्स इंफॉर्मेशन कोड दिन को गला. It is just information. I want to understand the system.
How we are saying.
कहा पाखरे आपण जो ऑनलाइन फाइल करछन सेटा कोठी जाउची.
सेट
हो ठीक अछि. और आपण डेट देबे वी कमेंसिंग 30 दिन.
Okay sir. Obliged.
आपण जान आपण भी जानना. आपण जे किस दिन करनांती विषय रे बसो. Yes, next. अच्छा आपण कॉल करछन सी इंटरप्ट कर देले सॉरी. None appears for the petitioner when the matter is called. The petitioner is also absent on repeated calls. आपको डाकिया के लोग अछंती petitioner को खोजिबे अनाउंस कर देबे का कोई अपन निजे पळांतु कोर्ट चलिबो ना एठी आपण बसंतु. None appears for the petitioner when the matter is called. The petitioner is also absent on repeated call. On 23/2/2026, the following order was passed. Court कर दिले पूरा order. Para. Apparently, though the petitioner is kept pending for the last more than 11 years, the petitioner has lost interest in prosecuting the matter. Accordingly, the matter is disposed of. Yes, next.
It's on to
Yes.
Position in the 125 proceeding I have annexed. Now, one of the development here,
First of all, first you address kete amount due, apana kete debe, केते देइछोती सिक्योर केमती करिवे तीनटा कथा अपन न देई पारंती बट सिक्योर इट बिकॉज आई विल नॉट गो ऑन ए फिशिंग एक्सपेडिशन अपन देबे कि नाही मु जानने नोटिस इशू करी स्टे करी ताकू ये करी you must understand that Supreme Court has interdicted this proceedings that it is a money decree and I mean
Now,
in this case
he has already filed a petition to get the marriage declared null and void.
fair enough that is not a ground to not to grant 125 in RPF. Filing of a section 13 application or 12 application is not a ground that I cannot direct that order I cannot pass.
No, that is the development I want to bring
Okay.
into
The
Lordship.
problem is that they are very hard bargainer. They are bargaining decrees, and court decrees to be bargained with the lawyer of the court is becomes very difficult because we have our hands tied.
But here, my lord, the case is that the materials available before the Lord trial court has not taken into consideration. The materials,
Consideration regarding what?
the material to the extent that, but in fact, she had married to another person.
Sir, those things are not there in the input section. Even that is how I mean DV Act, financial assistance. Any person staying together is enough. 125 also.
That I am
125, whether she is married 3 times, 4 times, or she is married to Pandavas, Panchu Pandavas. So that is not a suppose now. The whole problem is that the matter is pending here, kept pending here 7 years, 8 years, which is the exact concern expressed by the Supreme Court. I let him if he is not securing, let it is his choice. But can he bargain before in the revisional court? And the revisional court, the jurisdiction is very limited. Even suppose now I accept your contention that Judicial is liable to pay, Arjuna is not liable to pay. Then can I substitute my view? The answer is clear no. Justice Deepak Mishra judgment. So let him take a call on his choices. His legal choice cannot be a matter of subjective satisfaction of the court or the lawyer.
No, that's true, my lord. But the fact remains, my lord, is
If I record those statements, I have to reject those statements. I have no choice. I have no difficulty with recording that. You take a stand before the court that I'm not the husband. The court has satisfied that with evidence. Fair enough. You will not get anything. But in revisional court, in a money decree, you have to secure it. Don't pay her. Deposit it in the court, you return it. It is a good investment because court directs for investment in the highest interest bearing. He will get everything along with interest.
like in this situation, your lordship may
What about the child?
child, my lord, that is the child is also disputed. But child,
So let him go on disputing that. Let him have his choice.
because my lord, when she married to the petitioner, she was carrying at that time. She lost.
Sir, you are not arguing 13B. You are not neither arguing 13B or 24 or who is liable to pay.
Paying some days, my lord, that is to they are.
So once the court has rejected, he has a decree staring at him and he is bargaining the decree on various grounds. Let him secure and then argue these were very good points. Dispute the paternity of the child or maternity of the child or actually
So far as the
you
last,
should not have argued the illegitimate child because 125 covers illegitimate child, not expected. We are being watched. 125 is meant for illegitimate child. Legitimate or illegitimate.
the last
125 is meant for that. So that plea is not available in 125 or 144 Bharatiya Nagarika Suraksha Sanhita.
but all those things have not taken into consideration.
Yes, absolutely. That point is very well taken.
That's
But for that, he has to show minimum courtesy for the judicial process by securing the decree. So Niranjan Lenka for the petitioner. The learned counsel for the petitioner was heard at some length. In response to the order dated 5/2/2026, it is submitted by the learned counsel that he has not been able to persuade the petitioner to secure the amount directed to be paid by the learned court. Yes, adjournment.
What a chance.
Yes, then try to and seeks further adjournment. Hello? Stop. To grant further opportunity to the petitioner, the matter shall be listed in the week commencing 30/3/2026. Actually, this has become now endemic. All the RPFMs throughout, throughout the country, getting stayed and entangled in litigation. This 125 matters. Despite Supreme Court direction in Rajneesh versus Nayar, Rahul Shah to dispose of maintenance, nothing is working. Execution. Executions, how it is to be handled, there is an elaborate guideline. They are following it to the Supreme High Courts, will be followed by the trial courts. But the persons who are the litigants, they are following their own way. It cannot be done.
So while disposing of the cases, my lord, that direction in Rajneesh or Neha has also been not followed. Here, my lord, no.
But that doesn't to the benefit of the petitioner to challenge a money decree and not to secure it. Who is asking him to pay? I can record that he doesn't want to secure. In fact, today I have said that. Even if he doesn't want to secure, let him have his choice. Court, I cannot pay or you cannot pay. You must understand that. How the court will ensure that if ultimately the petition is allowed or dismissed, what would happen? It becomes a fishing expedition. Yes, next.
Item 3.
Yes, Mr. Office.
Yes, madam.
Alok Kumar Mahanti, Senior Panel Counsel for the petitioner. For the appellant. Yes, what do you say, sir?
I'll take notice question of limitation manner.
What is the reason for challenging the award, sir? Sir, it can't be that mechanical that you stand up and I look at you and issue notice.
No. The noting is that payment of court fee and
You will not pay the court fee.
yes, in the entire 20,000 and noting is there also.
What is the determined amount of court fee?
Number is 20,985.
IA 309 of IA 60,
80.
IA 86 of 2025. Along with LAA 21 of 2025. What is the ground of challenge, sir?
Round of challenge in the appeal, that's right.
Or I'll pass it over. Just go through your brief. Have a glance. Okay. Next matter to call Coram. Pass over.
Item 4.
As soon as you are ready, just tell me, I'll take it up. Mr. Nityananda Beuria. For Mr. Nityananda Beuria for the petitioner. The petitioner in the writ application challenges is the husband in the marriage. The challenge is to the order dated 2/8/2025 passed by the learned judge, Family Court, Keunjhar, under Section 24 of the Hindu Marriage Act, 1955, read with Section 151 of CPC, seeking maintenance pendent alike during pendency of the CP number 147 of 2022. So, the said CP was filed by the CP, the CP which is pending adjudication, the said CP which is pending adjudication has been filed by the petitioner husband in the marriage, comma, oppose petitioner husband in the marriage. সেন্টেন্সটা ভুলে যান the said CP marriage under section 13 of the Hindu Marriage Act. Stop. Para. The IA has been filed. The IA was filed by the minor child, then aged about 4 years, represented through his mother and the wife in the marriage. Stop. Para. The matter being in the list is mentioned by the learned counsel for the petitioner. Stop. Memo of date is filed, which states thus. Memo shall be taken on record. Scanned copy be updated. Alright. Accordingly, the petition stands disposed of. Copy of this order shall be forwarded to the learned judge family court Kendujal to be kept on the records of the CP number 147 of 2022, which also contains the IA number 12 of 2020, arising out of the said CP. Yes, next. Yes, next, please. Yes, Mr. Patnaik.
Item 5, already compliance petition has been filed, my lord.
Affidavit. Have you served copy?
Filed, my lord.
My lord, copy has been served on me.
So you want to take instruction or we will dispose it?
Millard, actually, the affidavit, compliance affidavit is not in terms of my lord's order. It is neither in accordance with law, but so if the contempt is done, then I may.
So if you want to challenge that order,
I'll
then you have to challenge on merits.
Millard.
Partial compliance is also compliance,
Yeah,
as the
Millard.
law has evolved.
Millard. So I may be given liberty to file a
No
statement.
difficulty. Liberty is always with you. Mr. Jivankanta Patnaik, for the petitioner, Mr. Prem Kumar Mahanti. You take your seat. I'll dictate the order.
Millard.
It'll take some time. The Prem Kumar Patnaik, additional standing counsel for the opposite party. Alleging that the order dated 18/11/2024, passed in WPC number 27818 of 2024, has not been complied with. The application has been filed under the provisions of the Contempt of Court Act. Stop, para. By order dated 19/1/2026, accommodation was granted to the learned counsel for the state to obtain instruction regarding compliance of the order. It is submitted by the learned additional standing counsel that compliance affidavit by the opposite party, collector and district magistrate, Puri, OP number 2, collector and district magistrate, has been filed, supported by affidavit dated 11/2/2026. Copy of the said affidavit has been served on the learned counsel for the petitioner. Indicating the compliance, it is stated in the said affidavit at paragraph 4, which is reproduced here. The learned additional standing counsel refers to the annex A/2 annexed to the affidavit that is dated 31/2026, passed by the collector and district magistrate, Puri. disposing of the application of the petitioner. Para. The Lord Counsel for the petitioner submits that the order dated 31/2026 is not in terms of the direction issued by this court. In stricto sensu. Para. The opposite for the delay in complying with the order, the deponent has the OP number 2 deponent has tendered unconditional and unqualified apology. Unconditional qualified lekha. Unconditional apology and has also explained the delay in complying with the order, which is accepted. Accepting the show cause, the CONTC application is dropped. Stop. The petitioner shall have liberty to challenge the order passed, the order dated 30.01.2026 before the appropriate in appropriate proceeding in accordance with law. Yes. Yes, next.
My lord, public.
Item 7.
So we're going to detail it special. You जाओ थोड़े बाटा पहुंचे शुरू डाक देवे नॉले पासवर्ड कोड सब.
Item 8.
डाक देवे उधर सब बुढ़ा.
Item 9.
Yes.
Item 10.
Yes, please. Next.
Item 11.
Yes, please.
Madam.
So they have marked that you mentioned the matter to be taken up. So nobody is appearing. You are Mr.
Naik, madam.
Ajay Naik. So Ajay Naik for the petitioner. Yes, yes, Mr. Naik.
And the petitioner has approached this honorable court on this petition 320 should be transferred from Judge Family Court to Judge Family Court at Puri, because there are other proceedings pending before the judge at Puri.
Who has filed those proceedings?
The wife has filed this proceeding.
So
Proceed to transfer.
show me on any case law on that wherever the wife files the cases, all cases have to be transferred there.
No, my lord. There are other pending cases before the.
So you follow what I am saying. Then why you are saying no? I have just repeated what you have said. You have said that other cases are pending at Puri.
Yes, ma'am.
I asked you who has filed. You said that wife has filed.
Yes, my lord.
The question is that where the wife chooses to file her cases, all the cases have to be transferred there. Show me any case law on that. Which decision of Supreme Court? Which provision in CPC or CRPC? Now Bharatiya Nagarika Surakha Samhita that how many cases the wife has filed?
There is one case pending in Nimapada from 2023, my lord.
Under which provision?
Under 498A 323 506 34-4. That is
so that's a criminal case to be conducted as because the cause of action is at Nimapada.
Yes, my lord.
Nimapada doesn't have a family court, but can't be transferred.
My lord, but Puri has a family court.
Have you traveled to Nimapada?
Yes, my lord, I have
What is the distance from Cuttack to Nimapada, or Khurda to Nimapada, or Puri to Nimapada? Any idea?
From Puri.
So because we filed 498A at Nimapada, so all cases to be transferred to Puri. So you rely on any provision of law, any section, any case law?
My lord, the husband has filed the divorce petition.
So we are not having any debate competition. You must understand. It is as if I am arguing with you. I am not arguing with you. I'm asking you a legally pertinent question, which you have to answer. You say that since the wife has filed 498 at Nimapada, so the case to be transferred to Puri. You see, so there may be hundreds of cases filed in a particular place. Can that be a ground? Because you see, you must understand, Puri is overburdened. The Cuttack is also overburdened. Then there is no nothing to choose. And somebody staying in Nimapada, and she files her cases, it will be trial at Nimapada, the trial will be conducted at Nimapada or the ADJ, whoever has jurisdiction. What other cases she has filed?
No other cases besides the criminal proceeding, and that has already reached the trial stage, my lord.
Let the trial be continued. Then why this CP should be transferred on that ground?
On that ground, besides that ground, my lord.
Have you understood the question?
Yes, my lord.
So you have any case law or any provision of law which says that CPC, suppose a criminal case is filed against the husband. So now the other cases, civil cases should also be transferred. Because as far as CPC is concerned, to my little, whatever I have read, there is no such provision. Family Courts Act, there is no such provision.
Yes,
so it is a judgment law.
Yes, my lord.
But convenience of filing cases against the husband should also be looked at. The husband is not a lesser litigant. You must understand.
Yes, my lord.
He has to file his cases.
Yes,
he has to defend his cases.
Yes.
Rather, he should seek that since I am facing trial in Nimapada, and then maybe both the cases should be taken up at one place. But he is not seeking. The wife has come.
Yes, ma'am.
Then what is the case law on this? Who case upar rely korchanti? Padichandi kiche? Who section?
24 CPC, my lord. Transfer the case, my lord.
Sitra achi the criminal case joti 498 hobo. Sida state.
No. Marriage.
Sida kai korchanti?
But marriage has been held over there. Child is continuing the studies over there, my lord.
Child divorce file child against who provision nachi Hindu marriage?
No, divorce has not been filed against child, my lord.
So joda ka legally tenable no, we are being watched.
My lord, the wife.
We are being watched by the audience, global audience. We should have a discussion which is legally nuanced. This is not a common room, drawing room discussion.
No, no.
The pila paಠ ପଢୁଛି ବାହାଘର ହେଇଥିଲା ସେଠି ଆପଣ transfer ପାଇଁ ଚାହୁଁଛନ୍ତି by you see he is the dominus litis. He files a divorce application. It is his fundamental right also. Recourse to legal remedy. But is it a lesser right than when the wife files a 498 case? So it has to be transferred to that
lesser
place.
right.
Then what is the law on this?
For the convenience, my lord, because both the parties are permanent resident of the Nimapada area.
So what is the provision that the wife's convenience is to be looked at only in the
No, wife's convenience should not be looked at.
If you do not appear, you appear through VC. The lawyer said Puri charging less, it is less expensive. The travel expenses from Nimapada to Puri is less. It's not that way. You were appearing at Cuttack, you conduct the case in Cuttack. For the case, wherever a personal appearance, Puri court, I can't exempt that whenever Puri case is listed, she will not appear before the court. She will stay at Nimapada. Must understand what you are arguing. The logic you are putting have to reflect in my order.
Yes, ma'am.
What is this logic which is not sustainable in law? You examine or I'll dismiss it today. You examine. You have to satisfy me on those points.
Yes, ma'am.
That because she finds it convenient to file 498A cases, wherever she files 498A, that should be the transfer.
No. That is.
And interestingly, here there is no court. 498A ADJ will be tried by the ADJ at Nimapada. It is available. Session ADJ, I mean, additional district just come session.
But from Nimapada, it will be convenient for the.
So what kind of convenience you are seeking?
And if it will be transferred to the court at Puri, then she could have attended this same.
Why she is not attending at Cuttack? Case at Cuttack. Why she will not attend the case at Cuttack?
Because nobody is in his family to caretake of the child, my lord. And
by going to Puri, she will carry the child to Puri.
No, my lord.
Then,
but that can be convenient.
She has to leave her child with somebody like maybe her parents or brother, wherever she stays. She can carry the child with her. That cannot be a ground that Puri is a most conducive place for children to be carried to court. Must understand. The child is not a pawn that whenever you want, you move the pawn, that child is there, so I will be at Puri. the child is not to be carried to the Puri court, not Cuttack court, not Nimapada court.
Yes, ma'am.
Child has to be in the custody of the somebody in the family. And if she choosing to carry, as you are saying that she will like to carry the child to the Puri court, then she should also carry to the Cuttack court. These are not the grounds. If there is any provision that because she has lost a 498-day case, we examine that case law. That much time I can grant you. Okay, ma'am. Hard learned counsel for the petitioner at some length. Take your seat. I'll dictate the order. I'll take some time. Okay. The petitioner husband is before the petitioner wife is before this court, seeking transfer of the CP number 320 of 2025. Pending before the allotted judge, family court, Cuttack, to be transferred to the allotted judge, family court, Puri. To support the prayer for transfer, they submitted by the learned counsel for the petitioner that the wife has filed FIR dated 12/9/2023 under provisions of IPC into brackets since liquid, such as 498-A, 323, 506, 34, Section 4 of the Dowry Prohibition Act, which is pending adjudication in the court at Nimapada.
Yes, ma'am.
Which is, as per his instruction, is pending adjudication before the court of jurisdiction at Nimapada. It is further submitted that paragraph. The minor child from the wedlock stays with the petitioner. Therefore, it will be easier for her to go to Puri. Para. In considered opinion of this court, the filing of FIR by the wife at a particular place before a particular, which is under trial before a particular court, cannot be a ground to transfer a CP, which is pending before the court of competent jurisdiction. So further, if the minor child should not be carried to the court at Puri. And in any event, if the matter is transferred to Puri, to the court at Puri, the child has to be left in the care and custody of any of the relatives of the lady, instead of carrying the child to Puri. Further, both the courts at Puri and Cuttack have a large number of pending matrimonial cases. By transferring the case from Cuttack to Puri, the petitioner does not get any advantage as far as consideration and disposal of the matter is concerned. Stop. At both the places, he has to seek legal assistance from the lawyer who shall appear on our behalf. Stop. If so advised, she can avail the ICT facility for conducting the case at both the places. The learned counsel for the petitioner has adjournment to obtain instruction and address the court on the above issues. List in the week commencing. Kebe sir?
The March 3rd.
List in the week. Sole week kochundi.
Hey.
In the week commencing 16/3/2026. Yes.
Well,
I would say add karibe on being transfer the matter has to be jo good line add karibe. The matter shall be renumbered to be a case of the year 2026. Second good line add.
The petitioner is a wife.
Yes.
She wants to transfer the civil proceeding from Judge Family Court Cuttack to civil proceeding Cuttack to Puri manner. Judge Family Court Puri.
Same.
Minus she has
Unfortunately.
minus she has no independent income and she and
Sir, Puri is equally costly. If I start recording your regions, then I have to give regions how the persons not having independent income it will be convenient for them to.
because she's staying with her parents there.
Whatever, sir, staying, the court will not be shifted to her place.
No.
Must understand, sir. What you are arguing, you have to reflect that on order.
Well,
My order, you have the freedom of addressing anything. But I don't have that liberty to mention anything in my order. That the petitioner doesn't have independent income, that is a good. So the Puri, it will be beneficial for her without independent income to pursue the matter. Because she stays at Puri, so the court has to be at her place. It cannot be.
the distance is
How
about
many cases she has filed against her husband?
one case.
Where she has filed?
Puri.
Let that continue independently. You see that the husband is not a lesser mortal. They are equal citizens, equal rights. And Kotak, you will not find a better lawyer than you were to argue at Puri. You will argue the matter here, you will appear for her. And for she is distressed, she is relying on you as a lawyer, then she can always rely on you here at Kotak. She will not find a better lawyer. No, without, I can tell you in front of you also. I am not praising.
There is any notice before and
No notice in these matters because the proceeding will be stalled. Maintain this, keeping the matrimonial matters pending and transferring them every now and then doesn't help in disposal of the matter. If she can come to High Court for seeking transfer, she can very well defend the matter at Kotak. Same order. The child.
she has no say.
Same order, the child Paradakhal Paibani. What line add ho? It is submitted that the petitioner has no independent income. In response to the said submission, it has to be considered whether the persons having no independent income has a easier and better prospect to prosecute matter at Puri instead at Cuttack. What line add about it? Yes. Can I ask you, Mr. Mahapatra? 9th week.
And
List in the week commencing 16th March 2026. Yes, next. Pass over कर दियो सब को तो बुढ़ा तो कॉलेज तो मानती अपन ready now no difficult अपन जो चाल सब you will argue the matter ठीक है जी अपन कॉल है जो बस 17 जगह कॉल कर दियो Miss Lakshmi Sharma for the petitioner. MS. Lakshmi Sharma for the petitioner. You are Lakshmi Sharma.
My lord.
Yes, please.
My lord, my prayer is before this honorable court for supplementary affidavit of examination in chief or recall under section 311 CRPC order dated 9/2/2026 passed by the learned judge family court in criminal proceeding number 109 of 2000.
So why you have filed the petition for the court and which is the order you are challenging this?
The order.
Which order you are challenging in revision? This is writ petition. In this writ petition, which is in the nature of a revision also.
Next is 7, page 67.
7 is the order. Okay.
Page 61 to 63.
Yes. Kindly place that.
My lord, here two petition filed by one petition filed by me and another petition filed by the wife. The petition filed by me is challenged before this honorable court.
The order dated?
The order dated 9/2/2026.
So CMC, asking CMC?
Criminal miscase number 119 of 109.
Sorry, no. ठीक है.
109 of 2019.
Can you place there?
Again. Order dated 9/2/2026. The petition which is filed by me is
You are not reading. You are only giving the introduction. I have been seeking. No,
Page
state
62.
entire order.
Entire order. Record is put up today for order on petition dated 15/1/2026 filed by the OP, wherein prayer is made for his re-examination in chief on recall under section 311 CRPC, and another petition dated 15/6/2026 filed by the petitioner to instruct of the defense of OP, since he is making default in paying the interim maintenance to them awarded by this court. Had LD counsel for both the sides.
Not LD, Learned.
Learned counsel.
That is addressed to you. So how can you make yourself LD? Yes.
Counsel for both the parties.
Sides, both the sides. Don't change any words or anything, add anything.
Both
Just
sides.
reproduce it. Produce the petition. Yes.
Produce the petition dated 15/1.
The problem is that it is not visible in my physical copy. Kindly you carry on reading.
Madam, 15/1/2026 filed by the opposite party for his re-examination in chief on recall under section 311 CRPC. It is seen the OP through his petition has submitted then inadvertently certain material particulars with regard to the adulterous conduct of the petitioner has not been included in his examination in chief, and he is required to submit supplementary affidavit in re-examination in chief to include, clarify the adulterous conduct of the petitioner and made prayer for his recall. Per contra, learned counsel for the petitioner submitted that the petitioner filed by the opposite party for his re-examination in chief under section 311 CRPC is not maintainable, and the same is filed only to cause delay in disposal of the maintenance proceeding. It is not disputed that the OP has taken the adulterous conduct of the opposite part of the petition number 1 as a shield to deny her maintenance. He is found to have asserted not visible here, my lord. Kindly the adulterous conduct.
Invisible orders are not to be.
My lord, this type of certified copy is communicated by the court below, my lord. That's why.
You should not have accepted. Suppose the law trial court makes it invisible. You also accept it. And I cannot, of course, I cannot because I have a limitation.
No.
You should not have accepted.
Option, my lord.
Yes, is what you are saying?
My lord. He is found to be asserted. Kindly the adulterous conduct of the petitioner on his affidavit examination in chief at a belated stage.
Slowly पढ़ो बुझी परिवे.
Again.
हाँ. ताले इटा नहीं सुनो अपने ताले सेटा बते पाऊँ ना थे.
62 page last.
अरे इटा अपने उल्टे की बात चल. 62 उल्टे नहीं चल. अब इतने देखा जाओ.
Again.
देवे आप. बुझीपार ना बुझीपार ना लाइटिंग करो तुम खोली हुए पड़ियो टैग टा बता दियो
62 and
लास्ट $62 upon Poduchanti, just kindly go through that. Read slowly.
It is not disputed that the OP has taken the adulterous conduct of the petitioner number 1 as a shield to deny her maintenance.
नहीं सेटा भूल पड़ुछन ता पूर्वटा पड़ियो तुम सेटा पढ़ियो चाहुनी he is found to
say
line करो
found to have
सेटा slowly पढ़ो
he is found to have asserted kindly the adulterous
asserted illegally asserted
adulterous
vividly the adulterous
conduct
conduct of the petitioner
on which affidavit examination in chief.
No, affidavit evidence in chief.
Again.
So that is how your petition has been rejected. He has done. So you have already taken and he has noted it in your favor. Don't spoil your case by doing this.
My lord, the fact which is stated.
No, you kindly interpret you speak Odia or Hindi.
Hindi and Odia both are.
So you translate that sentence in English or Hindi, whatever you like, or Odia. If you are not following that, he is found to have asserted vividly the adulterous conduct of the petitioner
on
his affidavit evidence in chief. So on may be a wrong preposition. It could be him. But your contention that you have not taken adulterous conduct to be a ground is not correct. Now look at your evidence in chief. Who pays Rachi?
Examination in chief.
Evidence in
Again.
After amendment of CPC, the evidence in affidavit is filed in all proceedings.
Again.
Who pays Rachi?
21 to 40.
Just kindly mark that.
Annexure 3.
Yes. Upon duty, wherever you have taken that plea in the paragraph, just mark that.
Para 3, para 2,
4.
Para 3, both the party belong to Tali. If
3, 4
again, 3 different occasions, yes.
So 4 also. So nothing is there.
4, 5.
So enough. So once you have asserted in your examination in chief in these details, so that is how the court says vividly. So you need not adduce any evidence.
My contention is just pray before this honorable court that the material which is available in my show cause that is not pleaded exactly not pleaded in my evidence affidavit examination in chief.
That cannot be allowed to be corrected.
That's why, my lord, I face some
There is no
trouble.
concept. There is no concept. Once, in fact, the court has recorded that. Because your anxiety that you have not pleaded the adulterous relationship, you will. Now look at
And in different
you look at recall 311 application also.
My lord,
Nothing can be more than 3, 4, and 5.
my lord, the recall petition.
Yes. 311 जोड़ा पढ़ो recall चाहूँगी. Just kindly read that.
55 to 58.
Yes.
Annexure
Yes.
5. 55.
Where you have stated regarding adulterous relationship.
4, my lord.
Yes.
Para 4 specifically I pleaded that due to inadvertent and oversight certain material particulars such as the approximate period when the opposite party noticed and no adulterous conduct.
These things cannot be re-argued.
My lord, just
There can't be, as I told you when you mentioned, that there can't be a preliminary, then Super 8, then semi-final, final, those things. It's not possible.
give liberty that at the time of the appellate stage, I raise all this contention before the appellate court.
No. That liberty I cannot give. I can't prejudge. You must understand that after you win the case, what would happen, whether she will file, or if you lose the case, whether she will challenge, whether you will accept the decree, the pronouncement, whether she will accept the pronouncement, nobody knows. You can't be in a predictive path as far as determination is concerned. You have to wait. You have to use you have to have the best points in your favor, argue there. At the stage of hearing, suppose final arguments. You argue all these points, what you have argued in 3, 4, 5.
The family judge hold that at the ability stage, I filed the examination or
Correct.
recall
You cannot,
examination.
there is no, you see, the court is under very strong scrutiny. You must understand. If he does that, then it may amount to misconduct by a judicial officer. He has to follow the law in letter and spirit. See, it cannot be at the discretion of the litigant that whenever he likes examination in chief and whenever any point, better point or worse point, because then it becomes a never-ending process. And you must understand then why there is res judicata, concept of res judicata. Why? Because there has to be a finality.
That's a different aspect, my lord. My lord,
And you must understand that it is not like a ruthless format like a 2020 match where one ball is enough to turn the match.
my lord, on
Here you have everything, all the steps are there. You have found enough evidence, you have pleaded it, you have laid the adjudication proceed.
my lord,
By reconsulting with another lawyer, suppose, you will find whenever there is acquittal or whenever there is a conviction, there are serious flaws which could have been avoided. But that is not a ground to reopen the issue.
but whenever
Technically, suppose you read the judgment of acquittal, you will find that a serious flaw has been made by the prosecution. In many cases, you find at the level of Supreme Court finds that the 323, I think, here 323, the question has not been put to the accused, which is a serious flaw.
my lord,
It is found that, is it that the matter will be again retried, he will be allowed to ask a 323 question again.
but here is a question of 125 CRPC, which is also
So
interconnected.
once you
with
take
divorce case also.
the plea of adultery, you cannot again, there can't be a better plea of adultery. That also you must understand. But arguing for yours, I mean, you must understand the point.
Stand.
There is nothing aggravated form of adultery or the lesser adultery. You have very clearly stated in your 3, 4 and 5. So that is enough. Yes, burden has to be.
Start the burden. I only pray before this one.
You can't have a second opportunity. You are already, if you feel that you have been
Supplementary.
unless there is a no ban, you can't be. Even so, if it is if you have returned to pavilion, then you can't be recalled.
My lord, that's why I am before this honorable court.
This is not a video referral to the appellate court.
My lord, only take a liberal view regarding supplementary
No,
fact.
liberal illegal view. Liberal illegal view, I
This
cannot
is
say.
not illegal, my lord.
Completely illegal.
Because
You see, I can record that, but that will spoil your case at this stage. You must understand. If I record and reject your contention in so many words, in fact, what binds me from not recording? Only a consideration that a lawyer is arguing against the interest of the client. The trial court is absolutely. And madam, you must understand how I find the fault with the court. It's a serious thing. Finding a fault with a proper order. The court, which part is wrong in that order? Do you read further? Can you read further? Because you are not having the copy, go to page 63. Every line is correct.
my lord, they stated that at the belated stage, I have to patch up the lacuna. These are the wrong contention or
The problem is that the court has not believed that.
that's why.
When after the pleadings are complete, after the evidence is complete, you start 311, you want to recall yourself on a point which you have argued already in evidence on record. That is precisely the wastage of time of court. The court is under strict scrutiny. You must understand that. That is one of the aspects of a judicial activity. A judicial officer is under very strict scrutiny.
My lord,
How do you expect how the court will respond if you are recalled? The other side comes to the High Court and files the petition.
they also have the opportunity to cross examine. My lord.
That the plea is taken, evidence is adduced, affidavit is adduced, then again recall for another opportunity. How can it be?
Whenever some fact is pleaded in my WS and that are not mentioned in my examination in chief, that's why the facts which
You must understand that then you are left with no option than to record and reject your contention. It is your choice. It is your choice. So that is how because it has to be to that extent. I always try to discuss instead of interjecting because it's to the point. If you say that since you did not say certain things, you want to because you are admitting the mistake. That cannot be a ground. There is no concept of improving a case. Then why there are acquittals and as I give you example, simpler example, perhaps simpler in the sense simpler to understand, but it's more complex thing. There can be a fatal error in the prosecution leading to acquittal. Is it that it is a presumption of innocence? There can't be. Presumption of innocence as far as trial is concerned. But there are eyewitnesses, but still the person gets acquitted. The fatal error in the prosecution.
My lord, here the husband is not an accused, only is a petitioner before this honorable court.
That's more the reason there is preponderance of probability.
My lord.
It is not proving to the hilt. If you're seeking an opportunity, I can't pass that order. Which part you are aggrieved? That you have to find out.
My ground,
This will unnecessarily delay the proceeding.
my
And
lord,
keeping the 125 proceeding pending is been frowned upon by the Supreme Court, High Court. There are several decisions that they should not be kept pending.
then my lord, only observation is that it is open to the petitioner at a.
So who has closed, madam? If the court has not closed, then how I am interested in this particular person that I'll give him a deduct? Court has not closed it. How can I presume that? By which order you have been closed to take any stand, argue anything?
My lord, the
You
50th
see, it can't be a figment of imagination, just to be on record. That is your imagination, but it's not on record.
that is not imagination, my lord. Some facts.
Then
which is not-
which line it has been closed? That you can't argue. You want to obtain an order from this court that I will argue this, that it shall be open. Who has closed that? That I'm asking you. Who has closed? How it has been closed? Rather, how it has been closed? Nothing is there. This is absolutely perfect order.
May kindly see my grounds, which is stated in.
You have to don't improve your grounds. You have to show me the 311 application and order dated 9/2/26 how it is portrayed.
Last para.
No, not last part. You complete it. You are not reading. That's the problem. That is the struggle you are making here.
Sorry.
The same thing perhaps you have made it, that not reading the order and nothing. You should, at least I have provided the legible copy from my copy. Read it.
Page 62, last para. Again, I just place before this honorable court. He is found to have asserted vividly the adulterous conduct of the petitioner on his affidavit examination in chief. At a belated stage, he has made prayer for his re-examination in chief to fill up the lacuna brought up from his mouth during the lengthy cross-examination, which ought not to allow in the premises the prayer made by the OP for his re-examination in chief under section 311 CRPC is rejected.
It has to be. You should have been careful in stating on oath that I have committed a mistake in stating. You can't resign from a statement. You cannot resign from a statement on oath. You cannot also.
I do not have any intention, or I do not have any.
So you have the best of intentions, but as a matter of record, if you have something has been recorded in open court on oath, that cannot be diluted.
Revert.
Leave it there. Leave it there. The more you argue, I'll record those things and I'll reject it, because that will not be in your interest. It is your choice. Then kindly read further. I also perused.
That is the prayer made by the opposite party.
Kindly read, madam. Don't explain me. I'm not asking you. Please explain.
I also perused the petition filed on 15/1/2026 by the petitioner, wherein they have made prayer to struck up the defense of the OP due to his default in making the payment of the interim maintenance awarded in their favor. Perused the case record. It has seen this court filed order dated 4/11/2022 had directed the OP to pay 3,000 to petitioner number 1 and 2,000 to the petitioner number 2, their minor daughter, from the date of the order 16/12/2019. On perusal of the case record, it is seen OP has made payment of rupees 20,000 to the petitioner on 18/8/2025, then 5,000 on 16/12/2026, and in between there is no payment made by him. In this meanwhile, execution miscase number 41 of 2023 for realization of the area maintenance amount of rupees 2,15,000 for the period from 16/12.
Maintenance of 13 lakhs. 1,30,000. Sorry, 1,30,000.
On miscase number 41 of 2023 for the realization of area maintenance.
2,15,000.
Again.
Okay.
For the period from 16/12/2019 to 15/7/2000, typo mistake, 26, and execution miscase number 54 of 2025 for realization of maintenance amount of 1,30,000 for the period from 16/7/2023 to 15/9/2025 are initiated by the petitioner against him. Be that as it may, Honorable Court, by order dated 26/11/2025, passed in WPC number 33230 of 2025, have pledged to direct not to take coercive step against him till the next date of the hearing, and the writ petition is posted to 23/3/2026, awaiting adjudication. In view of the matter, the prayer to struck up the defense of the OP is rejected. The same merit put up on.
A classic case where this High Court has injuncted a court, though directed by the so there is nothing wrong. In fact, madam, both the parts are in your favor. You cannot be allowed to re-examine after cross-examination. You cannot be allowed to recall a witness. If you want, I'll pass a detailed judgment. No difficult.
Madam, just the family court hold that there is a payment which I not pay to the wife. That is totally wrong view taken by the.
Well, that is not. You are under a 311 petition. Connected writ petition is listed today, where you have obtained an order of no coercive action. So they argue that matter. I am not concerned with that today.
I am also confined myself regarding
311, no case is made out. You cannot be allowed to again appear and again have a second innings, then they will cross-examine for the third time. That's not possible. That's not permissible.
family.
You have to examine the law on this.
Madam,
Nothing is there. I have done it counsel for the petitioner extensively. What is that?
order certified copy.
अच्छा आपको पे पटा तो उससे मत देखा तो 60 today 8 किलो into voltage. You take your seat. I'll dictate the order. I'll take some the hand and counsel for the petitioner at length. The petition, the writ application has been filed challenging the order dated 9/2/2026. Correct. By the said order dated 9/2/2026, the petition dated 15/1/2026 filed by the opposite party in CMC number 109 of 2019, who is the petitioner in the present application, asking for re-examination in chief on recall of himself, was rejected. Perusal of the order passed by the learned court is apparent that the learned court has given detailed reasons considering the application filed under section 311 for re-examination -chief on recall, which is reproduced here. And learned counsel for both sides to make it devoid of merit portion. Page 60-63. Yes, madam. Should I record that you want re-examination to cover up the lacuna you have in your cross-examination? If you say, I'll record and reject that. It is your choice.
No, my lord, there is nothing.
So leave it there. That would be prudent, because you never know, the case has not gone to that level. There is a distinct possibility that whatever you have argued, whatever material is there, I gave you a hint actually. I said that there is nothing called lesser form of adultery or. And when you pitch up very high, suppose you say that somebody has seen the adulterous conduct, then you have to examine the person who has seen it. He should come to on oath before the court. He or she has to give the witness, and she or he has to withstand cross-examination by the whoever is defending it. So you have to be careful there. I think by filing application stating these things, you should not have it.
No,
If the Laurel Court would have been of my approach, you would not have interfered to that extent. But it is because of you over enthusiastic. I don't know who conducted the trial. Being over enthusiastic, actually, you would mark that in cricket, if one starts playing one stroke too many, he gets out. This has happened here. Why did you expose your weakness in your chief examination in chief for cross-examination? And now suppose, let us assume. So, filed by the husband, by the petitioner husband, particularly paragraphs 4, paragraph 4, 5,
six,
4, 5 and 6.
and 9.
You have made it a speech which you can never prove. Whenever you file a written statement or any allegation, you are making the allegation. You have to be very precise in your allegation and 4, 5 and 6. Apparently, the finding of the learned trial courts that quote kar deve, that the opposite party in the proceeding, opposite party in the CMC proceeding, sentence ta thik mo bhuli gale, kon dekhle author that the UP through his petition has submitted ସେଟା ଅଛି page 62 ରେ ପଢିବନି ନିଅନ୍ତୁ ଫିଜିକାଲ କପିଟା ଦିଅନ୍ତୁ ଏଟା ପଢିବନି the opposite party quote kar deve, the finding that the opposite party is found to have asserted vividly the adulterous conduct of the petitioner on his affidavit dash evidence dash in dash chief contents is correct. Therefore, have you ever seen that after cross-examination, how many times they are recalled? Very rarely. That is the reason. Because you can't set the clock back. What I told you just now. It's a much greater risk in spoiling the case because you will be confronted with your statement. And the court cannot ignore also. And the court which has recorded your statement on oath in chief and cross both, ignore that. Cannot. Correct. Therefore, in considered opinion of this court, the order dated 9/2/2026 is just and proper. The petition stands disposed of. You want to withdraw?
No, not dispose of.
The petition stands disposed of. Stop. It is clarified that no part of this order shall be treated to be reflection on merits and contentions of the parties to the CMC number 109 of 2019 pending before the learned judge So and so and so. Yes, next.
Much obliged.
Yes. And the best thing is that you have made an effort. You could articulate your point actually.
Correct.
It is not important that whether you succeed or not. But you could articulate your point, and that is a learning process for me and for you, both of us. Once a student of law, I continue to be a student
Much
of law.
obliged, my lord.
Definitely. So, I mean, never hesitate to articulate your points.
No, my lord.
And gradually you find out the outlines also.
Much obliged.
Yes.
Item 15,
Yes, please, next.
I'm on VC, my lord. This is a very critical case as far as the child is concerned, because the family judge at Bhubaneswar has allowed the visitation on a weekly basis and also through video conferencing. My simple grievance is, when the impugned order was passed, that is at page 15.
Certified copy has not been filed.
No, we have applied for the certified copy. We haven't got it as yet. We have given an exemption application.
No, we have to remove that because that is not condonable. You have to file. Yes.
I understand.
And Mr. Acharya, you have to explain your client that vegetation and contact rights for a natural guardian is impossible for any court to prevent.
No, I am fully aware of that.
And the next point, and the next aspect, suppose, like in one matter, she says that she's a working lady, so at the time has to be, according to her, I mean, officers, maybe she is not there and she has to attend the child, all those things.
Right.
For that, you have to file an application before the appropriate court who has fixed condition.
No, here I am totally challenging that visitation, my lord, on very limited grounds. The reason being, as far as this child is concerned,
any provision or any case law on this, that vegetation right?
I'll just come to that. If we go to section 38 of the Special Marriage Act.
38 of Special Marriage Act.
Special Marriage Act.
Just a moment.
Yes, please.
Yes, please. 38.
I'll just read out. Custodial, actually that deals with custody, and the visitation also arises out of a custody application only.
So
in any proceeding under chapter 5
application.
Yes.
This is a 38 application before the trial court. Okay.
Exactly. And that 38 application is pending. During the pendency of the custody application, the husband has filed for interim visitation rights.
Yes.
So I'll just read out this 38 section for a moment. In any proceeding under chapter 5 or chapter 6, the district court may from time to time pass such interim orders and make such provisions in the decree as it may seem to it to be just and proper with respect to the custody, maintenance and education of minor children, this is important, consistently with their wishes wherever possible. So now what I'm trying to say, as far as this impugned order is concerned, the family court never took any efforts to call the child and take...
What is the age of the child?
She is 11 years old.
So not necessary.
No, because and then then I come to...
Kindly listen.
Yes, please.
She will be completely, tutored to be against the other parent. If she stays with the father will
quite possible. I don't deny that.
Why I said that it is not, it's of contact and vegetation rights have to be there, because counseling of the wishes of the child for contact and vegetation rights is not that material, but the custody is material, definitely.
Correct. No,
now she is with whom? Mother or father? Who is registering this?
With all throughout she is with the mother. In fact, for the last 7-8 years, the father has not taken any steps.
Correct. If she now stays with father, then she will be against the mother. So that's the problem if you bring the child into the picture.
I understand. But
why should avoid this? Because the child will be under a lot of stress.
Absolutely correct.
You will find the child doesn't remember. I have found here only. The child doesn't remember the school name, teacher's name, but she remembers the activity of the mother.
Absolutely correct.
So how is it that the child is having such a selective memory? In that case, not in your case. In that case,
I understand.
That's the problem why the court should not, as far as contact and vegetation rights are concerned, court has to be very careful in bringing in the child into the picture. Ultimate custody. Because the otherwise also suppose now the father is granted custody. Let us say It's example. We are discussing something in theory. When the mother needs to be granted visitation and contact right.
Right.
Then how because her right to have the
Absolutely.
visitation right and can be ignored. Same thing if the child is granted custody with the mother, the father has to have the visitation and contact rights.
Absolutely. I'm not denying that. I'm not denying that.
Yes,
but
yes.
we have to go by the facts and circumstances of each case, my lord. Here the problem is, for the last 8 years or so, the father has got no kind of contact with the mother or the with
That happens, sir.
child. That is
That
my
happens,
first point.
sir. It has happened. Sir, it has happened for
No,
14
no,
years.
Sir,
There are scriptures help. There are scriptures help that 14 years the father is not having contact. Mother is staying in US, in our state, mother is staying in US for the last 10 years or 15 years, he is not having contact. So it can happen. But that is not a criteria. That father did not have last 11 years.
And the
He cannot have the contact. Yes.
And another interesting factor is both the husband and wife, they're staying in Bhubaneswar only, in two different addresses or two different places. And interestingly, what has happened, this child was born in 2015. Immediately thereafter, maybe possibly in 2016 or 17, the husband has remarried during the existence of the first marriage, and the second marriage also he has a child, daughter. And the second wife also has lodged an FIR against this particular man because he has been torturing.
Those are who is the accused in the FIR, whether the husband of the informant should have visitation right. Those are besides the issue. Till the custody is decided, as far as interim visitation and contact rights are concerned, it has to be in a complete. The consideration are different.
No, I understand, but my
you are arguing can be the valid factors for custody, ultimate custody in 38, as you are saying that it's a 38 application under the Special Marriage Act. Fair enough. But contact and visitation rights cannot be curtailed. In fact, not being able to, whatever little I have, to my ability or whatever I have little understood, contact and visitation rights are completely different criteria. And more so when the person who seeks custody is not having the custody.
Correct.
Please appreciate that, because then if you bring the child into the picture, then it's a more of a problem. But your point regarding convenience or inconvenience, like as you have said, here the person is married. He has his wife, and the ladies have now started fighting. To the benefit of lawyers or otherwise, they have also started fighting. So that adds that list of 44. The Supreme Court has said 44 cases. We have 37 now.
Right.
To 37 between the ladies now, there will be more number of cases also. It may cross 44 also.
Right.
So that those aspects, you are right. That can be a factor as far as the place of visitation, time of contact, because the lady is working, suppose says, because she has to attend the child, spending for herself. Those factors are definitely there. In one case, I have marked that because she said that since I'm working, the time fixed is not convenient to me. So then the order I have passed is that let her approach the court stating these facts, because she has not brought these things to the court's notice.
No. And another important point in this particular case is, if you also will see, this impugned order was passed on 30th of October 2025. If the husband was really interested in the visitation for last 4 months, he has not even on a single occasion.
The custody petition is pending. The court is yet to determine and grant custody. Whether he's interested or not interested, I have nothing to say.
No. What I'm trying to say,
how the law has evolved. If you read that decision where as a matter of fact, the wife alleges that I have left my job, I am committed to the child, I am staying in for only to attend the child, still the Supreme Court grants the custody to the father. There the father is a murder accused in a foreign country.
Correct.
So these are the aspects as far as the natural guardian is concerned. Because if the paternity is not disputed, is the father, whether he is interested or not, that will be evaluated by obviously a point in
No. What I'm trying
Case, the main case.
what I'm trying to say, after this imputed order was passed, allowing the father to have visitations every week, both physically and through video conferencing. Now 4 months have passed. He has not even once come forward for a visitation. So that shows he never wants a visitation, but just to
That should make your client happy. That should make your client happy. So that is how she is not raising the issue regarding timing and all that.
Exactly.
Because many a times what is happening now, after the ladies have fought out with each other, then the school authority they start there is another issue.
Correct.
The school authorities are not allowing to meet. There are so many I mean, this branch of law.
I fully agree. Then may I suggest?
Yes, please.
Let this matter be kept in abeyance for some time. So let me see if the husband comes forward for a visitation.
I will not interfere with contact and visitation unless there is some difficulty. As I said, that extreme case is that somebody is accused in a case and he is facing trial. Still, the custody is granted, much less the visitation. I don't know whether they deposited the amount because the Honorable Apex Court directed 1 crore as security.
Right.
The child is to be taken to a foreign country, and then the child wanted to stay. The child want to have a better life for whatever reason. And whether now, Mr. Acharya, if you ask me, I'm not asking you, if you ask me whether a child of 11 year or 15 year can decide what is a better life, my understanding is that he or she cannot. Whatever we have seen, you and me, whatever we have seen about the world and all these things, but still then at times their view is given importance to.
Correct. But I have just got a judgment of the Delhi High Court.
Choose is there. Freedom to choose is there, but to have a informed and reason-basic decision, reason-based decision is difficult for a child actually.
But I'll just point out one more thing. There's a judgment of the Delhi High Court Division Bench 2023 SCC online. So
Yes.
here what the court has said, I'll just read 2-3 lines. Here the court has said, even if you are going for visitation, the child should be taken to the counselor and the child should be first put to counseling so that he or she is in a comfortable position. I'll just read out 4 lines because the judgment is just with me. I just got it right now. Prior to the meeting, I'm just reading it slowly. Prior to the meeting, the counselor at Delhi High Court Mediation and Conciliation Center shall individually or jointly have sessions with both the children, because in that case there were 2 children, child, both children, to allay their apprehensions, if any, and try to make the visitation rights more meaningful. Report of the counselor in respect of various meetings shall also be submitted to the court before the next date of hearing in a sealed cover. This is a division bench judgment. So I'm relying on this judgment and trying to say.
May I have my comments on that? Actually, this is the correct course to be adopted because the court is worried regarding the impact on the child for granting a visitation right. But here what has happened, I don't know whether the court interviewed the child here. You are saying that it has not interviewed.
No, nothing. I will have taken a specific
So now
ground have taken.
Now also the saving grace for you is that as far as the main case is concerned, that he is not, he is not accepting or utilizing the contact and visitation right. So that endures to your benefit also.
That I understand.
Yes, please. So you have to bring that to the notice of the court in due course whenever is required. So, but for staying an interim order for contact and visitation rights, it's a very difficult order to pass. And this thing, actually
can't it be this way?
Expose. My consideration, one more consideration would be that whether I should expose the child for, well, we are facing difficulty as far as counselors are concerned. That's another problem. We do not have trained child counselors.
Correct.
So to understand the child's feeling and psyche and other things, it's very difficult. And he is already under stress. He or she is already under stress because the wife, the parents are fighting.
Exactly.
Now another lady has joined being the mother, the second wife of the.
Exactly.
And they are separated. The husband and wife are separated now. Second marriage.
Yes. For the husband, second wife is staying together, I believe.
Okay.
But the first wife is separated for the last 8 years.
No, they have got a, legal separation or judicial separation?
No, not legal. Because the divorce is going on. The divorce has been filed by the husband.
Achha.
That is pending. The family court bonus.
It's a very complicated situation, much more complicated situation for a child also. So let us see.
Exactly.
The petition may be kept pending. It's your choice, or I can dispose it off without observing anything.
No, I would prefer if it can be kept pending, because another difficulty here is the court has said that the physical visitation should take in a garden or in a mall. Why not in the mediation center of Bhubaneswar?
No. Don't bring children to mediation center.
No, because here what has happened in
It has to be at a place where the child does not feel out of the place. Because you see, when the child enters any premises, he is noticed. He looks at people, how the people are watching the child.
Correct.
And the 11-year-old will be stressed. So rather you should insist for comfort of the child, convenience of the child, and let us see how the court reacts.
Exactly. That also, because the child has not met the father for last 8 years, and all of a sudden, if she's taken to a mall, how will she react? As a father myself,
the same child after 7 years will ask you, who is my father? That you can
absolutely correct.
Mother can answer.
I don't deny that.
At least seeks his or her identity through her parents, like her peers.
Exactly.
In her school or in her friends or in her family, every child is having the father.
Absolutely.
So
here the situation has become worse because of the second lady coming into the picture.
Keeping the child having for 8 years or 18 years doesn't like our scripture. I think Lava and Kusa both are born when Mata was in Agyatavas or something.
Yes, ma'am. So let this matter be kept pending for some time.
Father of both the twins. So that way,
let the matter be kept in advance for some time. Let the matter be kept pending.
Okay. The learned senior, Mr. Gautam Acharya, senior advocate, along with
Pragya Panda.
Ms. Pragya Panda and
SK Jamina Zahid.
Sheikh Jamila Jahid for the petitioner. The learned senior advocate was heard at length. The writ application is filed with a prayer for passing the order dated 30/10/2025, passed by the learned Judge Family Court, Bhubaneswar, in IA number 10 of 2022, arising out of CP number 1090 of 2022. The CP was filed by the
wife.
By the wife seeking custody?
No. The custody application was filed by the husband.
Exactly. The CP was filed by the 38 application is filed by the husband. The number is?
The number, 1 second, I'll just check. The number, it is 1090 of 2022.
So CP is seeking under the provision of?
Under section 38 of Special Marriage Act for custody.
No, I think CP is different and IA is different.
No, your lordship may kindly come to page 15. IA is 10.
So kindly mark the petition dated so and so under section 38. The IA is under 38.
No, my lord. Because the CP is also 2022, the case record is put up today for order on the petition dated 24/11/2022.
Do you have the past page of the CP? What are the past page of the CP?
No, if your lordship will see the entire 3 lines for the top, the case record is put up today for order on the petition.
I asked you this question. Because this is on that 38 application only.
In the 38 application, the CP is 1090, that is the custody application. And in that custody.
The CP is under which provision that I want to see?
No, under section 38, that is what the judge has said.
No. Judge has not said that.
Second line, under section 38 of the Special Marriage Act, filed on behalf of the petitioner husband, praying for custody of the minor daughter.
I'm missing the date. That is how the case record is put up today for order on the petition dated 24/11/22 under section 38.
Then if we continue further, it says, on behalf of the petitioner husband, praying for custody of the minor daughter for 4 days in a week and visitation rights during the weekends.
So you are sure that though CP is not there, CP was filed by the husband under 38?
Yes, 100%, 100%.
Husband in the marriage who is father of the child born from the wedlock. Father of the child, minor daughter born from the wedlock. Under section 38 of the Special Marriage Act, seeking custody lecture, no? Stop. The IE was filed IE was filed seeking interim custody of the interim seeking
Visitation. Interim visitation.
Seeking in the interim visitation and contact rights for the father as the child stays with her mother, wife in the marriage. It is submitted by the Lord Senior Counsel that the father had never visited the child earlier, nor seen the child. The Lord Trial Court, during pendency of the custody application, has not interviewed the child for allowing visitation and contact rights. In considered view of this court, for visitation and contact rights of the father, who is also the natural guardian, both father and mother staying at Bhubaneswar, the mother having custody of the child for the present. Interview with the child is not necessary, considering her age. Stop. That is 11 years. At her age, it will be difficult for her to take a view before the court whether her father should visit her or not. The Lord Counsel, so the Lord Senior Counsel seeks further adjournment. The matter stands adjourned to be taken up in the week commencing 30th March or
April assume.
April date केवे करछन्ती आपण 6th April.
That is okay, fine. That's okay.
To be listed in the week commencing 6/4/2026.
I'm grateful.
Yes, please. Yes, please.
16 Palace.
ଆପଣଙ୍କର ପାସପୋର୍ଟ ଟିକେ 16-17 ପରେ ନେଲେ ହବ ଆପଣଙ୍କୁ ପଡିଲାଣି କେସ୍ ମିଷ୍ଟର ବର୍ମାଙ୍କୁ ରିକ୍ୱେଷ୍ଟ କରନ୍ତୁ
ନାଇଁ ମୋର ଗୋଟିଏ ରିକ୍ୱେଷ୍ଟ ଯେ limitation is there in my appeal, so let me limit.
ଆପଣଙ୍କୁ ମେରିଟ୍ ନ ଜାଣିଲେ ଲିମିଟେସନ ଇସ୍ୟୁ କରିବେନି
ଆଜ୍ଞା
ମୋର ସବୁ ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ ମ୍ୟାଟର୍ସ ସେ somebody's property right
ଲ୍ୟାଣ୍ଡ ଆକ୍ୱିଜିସନ
ଆପଣ ଡିପୋଜିଟ୍ କରିଦେଇଛନ୍ତି ଆମାଉଣ୍ଟଟା
ଆଜ୍ଞା
anyway let us see ଆପଣ କଣ କେତେବେଳେ 2ଟା ବେଳେ ଆସିବେ ନା ଏବେ କରିବେ
2ଟା ବେଳେ
ଏବେ କରିବେ କି
2ଟା ବେଳେ
yes Mr. Burma 2ଟା there is a specific urgent matter the 2ଟା special bench ଅଛି urgent matter ଅଛି
ଆଜ୍ଞା
ଆପଣ ଏବେ କରିଦେବେ ରୁହନ୍ତୁ ଓ 1 ବାଜିଗଲା ତାହେଲେ ଠିକ ଅଛି 2ଟା ବେଳେ ଆପଣ ମ୍ୟାଟରଟା ଖାଲି ଦିଆହବ ନା ଆର୍ଜେଣ୍ଟ କଲେ ଆଉ ଗୋଟେ ଦିନକୁ ଅସୁବିଧା ଅଛି କି କୋଉ ଦିନ କହୁନାହାନ୍ତି ସେଦିନ ଡିସାଇଡେଟ୍ କରିଦେବେ କିଛି ଅର୍ଡର ହବନି ସିମ୍ପଲି ପୋଷ୍ଟିଂ ହେଇଯିବ କୋଉ ଦିନ କାଲି ପରଦିନ ନାଇଁ କାଲି ନୁହଁ ଏଟା ତ
6th
କାଲି ଆସିଲେ ହବ
କାଲି
ଆରେ when you suggest ଆପଣ କହୁନାହାନ୍ତି ସୋ ଡେଟ୍ ସମୟ ଯାଉଛି କାଲିଟା 6 କେବେ ଚାହୁଁଛନ୍ତି ଆପଣ କେବେ ଚାହୁଁଛନ୍ତି ଜଲ୍ଦି କୁହନ୍ତୁ
ଟୁମରୋ
ଏଇଟା ଟୁମରୋ ପୋଷ୍ଟ କରିଦିଅନ୍ତୁ ଫାଇଲଟା ଦେଇଦିଅନ୍ତୁ ହେଲା yes Mr. Burma.
My lord, the petitioner has challenged the impugn order dated 16/2/2026 as passed by the Learned Judge Family Court Bhubaneswar 2, but thereby allowing the application of the respondent wife to recall the petitioner at the fag end of the matter, my lord, after the both the sides evidence was closed, my lord.
The application ta dekhantu ago.
My lord.
Today coincidentally we discussed a matter so it is similar.
Yes, well,
but in a little bit different. Actually different.
Application is page 37, my lord.
ଆପଣ input order ଟା Can you will come back at 2 or you have difficulty?
No, I don't have much difficulty.
But there is a specific special bench at special bench. There is a special bench at 2 and one specific personal appearance matter at 2.
Yes, well. So 3 o'clock it will be taken at 3 o'clock or something, or I can wait at 2 o'clock.
No, already there is a bench, another bench actually. Those the same judge, I mean me, but our bench is different. So when do you want, tomorrow or?
Tomorrow, well, it is a bit urgent matter. Tomorrow it can.
Consider correct 8 o'clock tomorrow. Yes. But next day, Mr. Akshay Sahoo, yes, he's there. Tomorrow?
This may be issued. The appellant is the wife of the respondent. Guardianship petition has been filed by the husband. That was allowed on the ground that the husband has stable income. And the child's statement was not taken into consideration. Your Lordship may kindly see the running page 50. He is staying with the mother and comfortably living and studying in a school at Kendra Vidya.
So is there any execution? Execution kale ki apon husband father jota nele decree granting custody.
No. File korchuni ne more.
Court provision 38.
26 of the
Convention What's Act? 26 of Minority Guardianship.
Marriage Act and 7 of the Minority and
Guardianship. Okay. Okay, take notice. You have argued very briefly and sufficiently also for issuance of notice. Mr. Akshay Kumar Sahoo. No, stay 7 asunto. Situation ko mate jana nahi.
Unless
appearance parjanta jodi apon nije jani nanti kon situation sir, how the court will move, I have to dictate na nahi. What I will dictate? My order cannot be empty. You must understand, sir. You take notice in the IA also.
Man.
So Akshay Kumar Sahoo for the petitioner. You take your seat. I'll just take 2 minutes to dictate the order. The mother of a minor child is before this court challenging the judgment dated 27/12/2025 passed by the Honorable Judge, Family Court Sonpur in civil proceeding number 09 of 2025. The said CP was filed under section 26 of the Hindu Marriage Act, read with chapter 7 of Minority and Guardianship Act 1956. Stop. The CP was filed seeking custody of the minor child after the marriage between the parties was dissolved by a decree of divorce dated 29.07.2023. Para. Had learned counsel for the petitioner issue notice along with this order. Requisites for issuance of notice by speed post with registration and proof of delivery be filed within 5 working days. Within 5 working days. List after SR, liberty to mention. IA number 5 of 2026. Had learned counsel for the petitioner issue notice as above, accept one set of process fee as well as postal requisites. List after SR, liberty to mention. So, again, so since this the same judge is having a special bench, I can maybe I'll be taking up some matters. But there is I'm in a special bench assignment.
Item 9.
Sir, what we can do, sir, we can simply reproduce the list tomorrow.
No matter, I want to adjourn the matter.
Arjun Jyotre, both of you are agree.
No, this is a fresh admission matter. Item 9 pass over matter. What's the make on 6th or?
Apone date कर देंगे जहाँ को week रे आसियो से कह देंगे. Specific नहीं है कि week commencing है
Week comment.
Yes.
Item 8. Adjournment.
ठीक है कर देंगे. No difficulty.
Item 9.
Already we have been able to because some hearing matters were there, so that is how. And there is a special bench at 2 p.m.
Item
So
13 can
we
be
have
taken
to
after
take up those
recess.
matters.
Item 13 can be taken after recess.
So that bench is at 2 p.m. I was trying to, because that is not at 3. I had impression it is at 3 p.m.
But tomorrow, my lord.
I have the same, since I am sitting, so I can technically, but there is one personal appearance matter. So let us see how the things are unfolding. So whatever matters you can, upon Kali asi paribo, yota seta kar debe. But not for after notice matters. Approach le mere body jo.
My lord, item 23.
Yes.
2 RPF matter is there. Both are for withdrawal. We have filed IA for withdrawal.
जोड़ा withdrawal अपन लिखी की दे दियो.
My lord, IA is there.
IA already recorded अच्छी.
One is recorded and this one is I am taking.
सेटा numbering ही जाइची.
No, my lord.
करिक नहीं आसुना. सेटा टिके तांकर सेति अपन हेल्प करि परिबे. से फाइल कले अपन मगे देबे. हां ठीक है.
Your lordship.
नॉले सेटा अपन काली आसले कोन सुविधा होची. बेटर होता है एटा कोन सेटा रेकॉर्ड टा फाइल लेला पर नंबर करिकि काली आनि देबे.
Your lordship, item 18. Your lordship, the brief has been transferred to us. I'm just reading the wakalatnama, your lordship.
सुनନ୍ତୁ सेटा I understand, but I have to pass that order. It will be repeated tomorrow because of that special bench matter. So I have to again take up those matters. There is a special assignment.
Item 28, ma'am.
Yes.
What is, sir? I want.
I have told you, sir. Take a date, whatever convenient.
Adjourn, my lord. Item 21. Adjourn.
You want adjournment?
Yes.
Take it, sir. He will give you.
Okay.
Yes. Section 5/2025 shall continue till the next date of hearing. Yes. Yes. Date ଆପଣ କେବେ କହୁଛନ୍ତି? Date କରିଦିଅନ୍ତୁ. That shall be listed in the week commencing. 6/4/2024. 26 rather. 24. Yes, please.
Sir.
Your item is?
35.
अच्छा आउ मेमो केतोडा जो देचंती पछगोर आउटे मैटर काली को रखिले मेंशन कले दीटा मेमो थिला बोली ठीक है गोटे आईए अछि आउटे आईए आसीनी गोटे लिस्ट हेछि आपण कले जे टायरटा नै आसीबे just give us a moment. Only one matter is left. You take your seat.
Item 90.
Mr. Dakshasis Darshan Nayak for Mr. Sunil Kumar Ponda for the petitioner. The petitioner in the petitioner in the present petition seeks for has prayed for quashing of order dated order dated 10/6, judgment dated 10/6/2022, 10/6/2022, passed by the learned judge, Family Court, Berhampur, in criminal proceeding number 73 of 2018. Stop. By the said judgment, petition filed under section 125 of the CRPC, into brackets, since repealed and substituted by perimeter provisions contained in Bharatiya Nagarika Suraksha Samhita, filed by the wife in the marriage and the child, then a minor, was allowed stop. However, instead of the amount of rupees 10,000 for the wife as sought for, rupees 8,000 was granted. And the child was granted rupees 5,000 per month towards maintenance. The matter was presented on 22/7/2022 before this court. It was placed before the Lozima, before the deputy registrar into bracket J, bracket closed, Lozima, for removal of defects. On 24/10/2025, and time and 3 weeks time was granted. Stop. Thereafter, on 15/1/2026, it was listed before this court, and 7 days time was sought for by the learned counsel for the petitioner to remove the defects. Stop. Para. Today, the matter being in the list is mentioned by the learned counsel for the petitioner, and memo of date is filed, which states thus. Memo is taken on record. Scanned copy be updated. Accordingly, the petition is disposed of. Copy of this order shall be forwarded to the learned judge, Family Court, Punjab, to be kept in the record of the criminal proceeding number 73 of 2008. Yes, item 35.
Yes, happy.
Yes, so what has happened?
Sir,
After you
as
got a
per-
school.
Yes, I have identified one school, Venkateshwara English Medium School, Unit 4, Bhubaneswar, where I have also paid the provisional fees.
No, I mean, both of you could go to the...
Sir, mother is not staying here. She is working in a company in Gurgaon. The company name is Striker Technology in Gurgaon, and she could not participate in the process. Last week, she might have come, but I am not sure. But in the meantime, I was visiting schools, and after 6 attempts, finally one school was gracious to offer the admission.
When you went to 6 schools?
No, 6 schools. I have gone to multiple. With son, I have gone to 6 schools. So first, we have to identify whether seats are available or not. After like so many rejections, finally Venkateshwara is the one which has offered him a seat.
In standard one?
Standard one.
Okay.
The mother is very much available in the same residential house. The child has been taken for admission without informing. But now I am seeing certain mails have been issued to the mother. And I contacted the mother now only, since it was supplied 5 minutes earlier. When I contacted, mother said, I have not gone through my mail. So he is visiting the child, everything. But the same was not physically communicated to the mother. Moreover, how could mother take or inform the child to the father concerned? Because on the last date, my mother has ordered to hand over a copy of the Aadhaar card of the child. For anything, she has to go to school. An identity card, or that is Aadhaar, is required. And that has not been supplied to the mother. And she has been asking that.
Have you initiated that of the Aadhaar card for the child?
Sir, I have given the Aadhaar card to the child after on the 6th or 5th जो दिन हम डेट थिला तार नेक्स्ट दिन जो दिन हम विजिट करले सेही दिन छुआ हाथ रे आधार कार्ड पठेइथिली सर मां सुनन
नहीं नहीं petition is dismissed.
Sir,
what is the direction to hand over the Aadhaar card
sir,
to the child?
I have given sir I have given.
Sir, where is kindly find out from the order where I have directed that you will hand over the Aadhaar
sir,
card to the child.
sir,
No, kindly read, sir. This is not a
Sir,
place
I
of making
don't
fun
have that
of each other.
Sir,
So where I have directed that you will hand over the Aadhaar card to the child. Kindly find out.
Sir, last date रे कुहा इतला जे आधार कार्ड.
Sir, kindly don't make a fun of us.
Sir,
either you are joking here or not, I am joking with you.
Sir, I am.
Why did I ask you to submit the Aadhaar card to the child, as you have said, because it is now recorded, no difficulty. Your statement has been recorded.
Yes, sir.
So it is dismissed.
Sir, please, sir.
Sir, kindly don't make a fun of the process.
Sir, I have.
Sir, we are funny, looking funny, but we are not here to make jokes.
Not.
Have you initiated the process of Aadhaar card? Your answer is that I handed over the Aadhaar card to the child.
Sir,
where was the direction for the Aadhaar card to be handed over to the child?
Sir, if nobody coming. Sir,
you should have come to court and given it here. Not the child. No.
Sir, in my bag only I have it.
No, you dismissed.
Sir, please, sir.
Sir, here, please don't make a fun of the whole process.
Making a fun, sir.
So why did you hand over the Aadhaar card to the child?
Sir, if sir,
who asked you? Who asked you?
Sir, छुआ को खेलना दो जो.
आप कहाँ भी खेलना दो तुम्हें?
Sir,
why did you make the child play with the Aadhaar card?
No, sir, I am not giving.
Sir, this is not done, sir.
Sir.
Sir, here, neither you can throw tantrums nor I can throw tantrums. You have to go by law.
Aadhaar card in my bag, sir.
Sir, you should have obeyed the court's order.
Sir, I have.
You have not.
Sir.
You show me the document. Show me the document you have initiated.
Immediately more back and nahi.
Sir, don't forget.
Sir,
don't forget immediately.
1 minute, sir.
You don't have answer. I have immediately justice to do.
Sir,
no, this is not
1 minute, sir. Sir, 1 minute, sir.
Sir, please, 1 minute. You must understand you are in a court of law. This is not neither your place or not my place to have these exchanges.
Sir,
you must understand.
Sir,
very well said. I have noted and it is recorded.
Sir, 1 minute. I just.
Have you handed the card to the child?
Yes.
Did you visit the wife?
Sir, I have gone to their house multiple times.
Did you meet her?
No, she's not there.
I am recording and dismissing. Permitted by the. So kindly please allow the order to be passed. Both of you sit down. Sir, this is not time to be spent like this.
Sir, I just have one.
You find your memo. What you are saying.
Sir,
you file your
sir, I just want to highlight one thing.
Sir, this is not an answer to the for every highlighting or not giving.
Sir,
any light, so you must understand what you are doing.
Sir, I just
this is not a place for that.
Sir,
I'm not here to join issues between you and your wife or the child.
No, sir.
Have you complied by by initiating the process? Have you visited the sir, you showed me the no.
Sir, I am just showing you.
Sir, you should have.
Sir, I am.
Sir, this is not a shop you handle.
No, sir, I am in the. Sir, 1 minute, sir. Sir,
please 1 minute. Don't pretend that as if I am not giving you the time.
No, sir.
I have given you the time. You have been given time since 5/2/2026.
Sir,
we are to 26th of February.
Sir,
have you completed?
Sir, may I just one thing I want to.
Instead of saying, have you completed?
I have with intent. I have given.
Sir,
Sir,
why did you hand the child? Why did you the child?
Sir, I have requested. Sir, I am.
Sir, you should have come to the. Past.
Yes, sir.
I cannot. You see, Mr. Listen. I cannot violate my orders. You may.
I am not, sir. I have, sir. जो आपने order देखले 5 तारीख दिन, मु 7 तारीख दिन सप्ताह में mail पठेली जे.
Sir, I am not directly order.
Sir, how do I communicate to the wife?
That day.
Sir, email communication, sir.
Counsel for the petitioner appears in person.
Sir, email is normal communication, sir.
Sir, you should have told that I will send mail. I should have directed you to send mail.
Sir, I have given the.
Why in the order? Why in the order? Asked you to send mail.
Sir, वो केमित पठे विदाल sir.
Sir, then you should question that way, not today.
Sir,
sir, we are not sitting as if I am related to you or
no, sir.
I will record that.
Sir, I just.
Can you please take your seat and proceeding? Yes.
I am just requesting you to.
Yes. I am also requesting to be having some intelligence to understand what I am telling you. I'm asking you, when did I ask you to send mail? Who asked you to send mail? You must understand, you are saying that as per the court's order, you have sent mail. Yes, where in the order? Sir, you may have some imagination or some interpretation. If I have directed you to send mail, then say that. Don't put words to my mouth.
No, I'm not.
Why did I ask you to hand over the Aadhaar card to the child?
Sir,
Your submission will be recorded and diligently recorded. You see, it is not that the court will escape like you are escaping.
No,
please sit down.
Sir, I am giving. I have.
Sir, please sit down and listen to the order. If you want to stand, you continue standing. No difficult. The matter is taken up to be marked at 2 p.m. and is taken up. It is submitted by the petitioner appearing in person in response to the court's query at particularly paragraph 12. Whether the said paragraph has been complied with by both the parents. It is submitted by reply kale what he has said. Reply kariyo. You have stored it. Okay. Paragraph 12 of the order. You read paragraph 12 of the order, Mr. Patnaik?
But I remember the order that it was.
Sir, don't remember. Sir, I'm not as brilliant as you. You have to read it. That reading from para 11.
The concern of the father regarding the school admission process having already started and progressed substantially is common knowledge. Therefore, both petitioner and opposite party are requested to have convergence as far as the studies of the child is concerned. Both are directed and are expected to cooperate with each other in finding out the schools where the needs of the child and his interests are adequately taken care of.
So that's the question. Now you take your seat, you have answered that. Paragraph 12 ta quote kar debe, which is quoted here.
Sir, I have.
In response to though the petitioner again and again interrupts while the order is being dictated, that I have. But he has submitted, which is a part of the record in the VC. That's the mother of the child does not stay in Bhubaneswar. She works in Gurgaon. He could not meet the mother of the child to comply with the paragraph 12 of the order. Mr. Swarup Lorek counsel in response submits that the mother of the child is very much present at Bhubaneswar at her place of residence. And regarding compliance of paragraph 12, it is stated that the paragraph 12 as the direction has not been complied with by the petitioner who appears in person. In response, it is submitted by the petitioner appearing in person that he has sent email to the mother of the child accordingly, it was asked to the petitioner appearing in person that by which portion of the order he was directed to send email to the mother of the child. In response, he submits that he is unable to point out any part of the order where he was directed or asked to send mails to the mother of the child. He asks a question to the court, how else he will communicate? In all fairness, that question is not pertinent to be answered in any manner by the court, much less to be given any importance for adjudication of the matter. Apparently, the petitioner has failed to comply with the paragraph 12 of the order, directing both the parties and also expecting both the parties to cooperate with the order in finding out a school where the needs of the child and his interests are adequately taken care of.
Sir.
Again, he interrupts while dictating this order, which he is not allowed to. Mr. Swarup, referring to the paragraph 13 of the petitioner, of the order dated so and so, 5/2/2026, regarding the difficulty faced in taking the child for admission to any school, and provision of Aadhaar card for the child. Paragraph 13 of the order is reproduced herein. It is submitted by the petitioner appearing in person that he handed over the Aadhaar card to the child on a date which is not able to recollect. In response thereto, a query is made from the court by which order, which portion of the said order the petitioner was directed or asked to hand over the Aadhaar card to the child. Is it about? What is the age?
Age 6.
6 years. Again, the petitioner has no answer, apart from repeatedly saying that he has complied with the order. Though with utmost care and concern, the matter has been dealt with, as would be evident from the order dated 5/2/2026. The petitioner has not been able to prove his diligence in complying with the orders passed by this court, which is not at all adversarial, rather in the nature, rather conciliatory in nature, as would be evident from the language used and the directions issued. For the reasons best known, the petitioner has not been able to meet the mother of the child to search for the school. As stated by him, though without any affidavit or any other document, it is submitted that he has visited 6 schools and one Venkateshwara English Medium School, Unit 4, has agreed for granting admission to the child. At this stage, in view of the conduct of the petitioner, no further order can be passed. The matter stands dismissed, or Arjun, what do you want?
Sir, I just want to show you that I have prepared the additional affidavit to file today only.
Sir, I'm not here to invite you to file affidavits. It is the petitioner raises his hand and says that I have prepared my additional, he has prepared some additional affidavit to be filed in the court. Whether he has prepared or not, the fact remains that he has not filed any affidavit indicating compliance of the order dated
5/2/2026.
5/2/2026. Nor he has responded to any query positively regarding the compliances to be made by him, apart from sending email to the mother of the
mother
child.
Also responded to the email. Sir, then
Sir, you may exchange so many things. The question is repeated, sir. It is not that you are so ignorant that you are not following. Which order directed you to send email to the mother? I've been asking you.
Sir,
between you and the mother of the child, or maybe your wife or ex-wife, I don't know. You do whatever you do, but I'm asking you regarding, because I can't enter there. Just understand that. I have to follow my order.
Sir, I am just trying to explain to you.
So I'm also trying to explain
Sir,
that.
1 minute.
Sir, 1 minute, please. By which order? By which portion of the order I have directed you to issue email?
These are normal communication.
Sir, very well. Sir, it is a normal. Normal order to be passed.
Sir, email ରେ ଆମେ କଥା ତ ହବୁ ଏକା
କରନ୍ତୁ sir. Please, who has prevented you from sending email? As if I have, now you are saying as if I have prevented you from sending email.
saying that
Sir, I am asking you how you have, when you visited the school, when you met the mother, because I have recorded your answer that she is not there in Bhubaneswar. She stays in Gurgaon.
Yes.
That's it. Leave it there.
Sir, but I have informed the mother throughout.
Sir, they are informing, no difficulty, sir.
Sir, phone call.
Sir, I do have a much softer voice than you. That will impress everyone.
Saying that.
Sir, sir, please understand, we are in a court of law. I can't deviate from my order. If I have not directed you to send email, I cannot say that you go on sending email.
Sir, can I just say one more thing?
Sir, you'll have your time, sir. Entire day is there for you.
We have responded to any query particularly regarding the contact made by any apparently sending email to the mother.
Apart from, upon बढ़िया English लिखले. Apart from sending email to the child and handing over the Aadhaar card to the child, which is not sure when he has handed over. What happened to the Aadhaar card? You have handed over in original.
No, ମୁଁ ତ xerox copy ଟା ଦେଇଥିଲି.
On being asked what happened to the original of the Aadhaar card, he says in Odia, ମୁଁ ତା xerox copy ଟା ଦେଇଥିଲି. Quote କରିଦେବେ. Which means he handed over xerox copy of the Aadhaar card to the child. The order dated 5/2/2026 and the acts of the petitioner would indicate that either he has purposefully or otherwise has not been able to comply with the order dated 5/2/2026. Accordingly, yes, what do you want?
Sir,
dismissal or adjournment?
Adjournment, but I just submit two things.
Now, on being asked whether he wants the matter to be adjourned or dismissed, the petitioner submits that he wants the matter to be adjourned. Yes, please carry on.
Sir, on the 7th of Saturday, on the 7th of February, Saturday, I sent an email to the mother saying that I have visited these schools, and you tell me which school we can go. So,
sir, again, after the completion of the order, the petitioner seeks leave to address, which is allowed. And he again reiterates that he has been sending email to the mother.
Sir, mother also
giving the details of the schools he has visited, which is not contemplated in the order.
Sir,
again, which the order you are missing, you kindly read it.
Sir, in response, para 10. Sorry. Para 10. In response to the learned counsel of the
para 9 भी पढ़ो.
In the writer side, the petitioner opposite party converge on the point that both of them want welfare of the child and the child to continue his studies in a very good school with best of the amenities and facilities. It is submitted by the petitioner due to dearth of seat in the higher classes, as the number of available seats in school is less compared to the number of students. Usually, child gets admission at the stage of preschool in a school where education is available up to standard 12. It is further stated and submitted by the petitioner that at Eurokid Sujanagar Bhubaneswar, there is no avenue for further studies beyond preschool. Therefore, admission of the child should be explored in schools where education is available up to class 10 or 12. It is submitted. Opposite party mother should also take steps for getting child admitted in a school where class 10 or 12 are available.
Now, Mr. Patnaik, you are Mr. Patnaik.
Sir.
Yes.
And
so why I highlighted para 9, because these are your submissions which have been recorded.
Yes, sir.
So nothing has been left also. I think, sir, you will be satisfied that yes, your submissions have been noted. Then kindly read them.
Okay. In response, the learned counsel of the opposite party submits that the mother opposite party fully agrees with the concerns regarding the study of the child. Learned counsel, upon instruction and as has been stated and pleading before the learned judge family court, refers to the issue regarding the child having attention deficiency hyperactivity disorder. It is submitted that it would be in the best interest of the child that he goes to a school where a child having ADHD gets the best opportunity and gets adequate attention. So,
yes, kindly read further.
Okay. From the above interaction and hearing in the court comes to the conclusion that both parents are concerned regarding the education of the child Both of them have a lot of love and affection, as it would be natural for them towards their child. The concern of the father regarding the school admission process having already started and progressed substantially is common knowledge. Therefore, both petitioner and opposite party are requested to have convergence as far as the studies of the child is concerned. Both are directed and are also expected to cooperate with other in finding a school where the needs of the child and his interests are adequately taken care of. This court also observes that petitioner as well as opposite party will rise above their individual differences and perception about each other for the welfare of the child to give him the best of life according to the ability of the parents. The parties are directed to go to school together while inquiring about admission. Mr. Swarup, Learned Counsel, submits that there is some difficulty in getting the Aadhaar card of the child. The parents shall initiate the process for obtaining the Aadhaar card and or other identity proof. List on 26 to the.
So that is how I said that this part of the order regarding the parents going together to the school, you say that she is not available.
Yes, sir.
So I can't direct that she will be arrested and produced together. So no problem. So leave it there.
Sir.
So you send me or she may send you mail. No difficulty, sir. Sir, that is not my lookout. The petitioner, on being asked that he has not complied with paragraph 13 or 12 of the order.
Sir,
he asks admission kouthi karahabo tahale, which translated to English would make a sentence where the admission will happen. In considered opinion of this court, asking the question to this court needs to know where, and nothing turns on the said question, either to be answered or not answered. Yes, next.
Sir, sir, my point, I am saying that I have taken my son 6 times.
Sir, if you are not complied,
sir, I have, sir,
sir, sir, whether you take your son to any, but if you have not joined together and gone, sir, I am concerned with that.
Sir, I am saying, sir, I am just requesting the court.
Sir, already recorded. You have taken your son to 6 schools and accepted, sir, that I have recorded.
Sir, not only that, sir, I am trying to submit to the court that, sir, when I request the mother to come, if she not come, then I will still have to try to get my son admitted. Sir, just 1 minute.
Your son is unfortunate, or you are fortunate, or she is unfortunate. That is besides the issue.
Sir, but
sir, it is also submitted that the petitioner has been requesting her wife to come and she doesn't respond.
She does not respond. Sir, I can show you the. I have said the email.
In considered opinion of this court, nothing turns on the said submission as far as the admission of the child is concerned, and paragraph 12 and 13 of the orders are concerned. Order dated 5/2/2026 is concerned. Yes, next.
So next point is, sir, if they have any school, I am happy to,
sir,
whichever.
Sir, here I am not a matchmaker or for admission counselor. You are asking me the next the petitioner asks if they have any school, then he'll be very happy.
To support
in consideration of this court, asking this question to the court whether the other side has any school. That means whether the other side has identified any school is of no avail for adjudication of the matter. Yes, next.
I don't have any.
Yes.
I have just.
After you complete it, then you allow the other side to say. Have you completed your submission or anything?
Yes.
Because here is a case, it has to be absolute equality. It is not that you are a lesser mortal or I will not record. I will record, diligently I will reproduce. But that should lead to some adjudication or some conclusion.
Sir, I am.
Because asking questions is not there to be.
I am just submitting.
So I hope you have already said whatever you wanted to say, or if you want to continue, then you continue. Then because actually there is another bench at 2 p.m. also. Because since I have fixed your matters, I am taking up. If you have anything else you want to say, or then allow you to say.
I am just requesting that the court to take cognizance that there is only.
This is not a cognizance taking court.
Well, basically take note or basically something that 15 days to 20 days for a school good aramba
So that I cannot, sir. It is the fortune of the child, sir. I cannot direct the nature of the God to, what you call. It's a fundamental right as we confer that say he should have luck enough to get admission in a good school. There are so many children not getting. Is the court able to help them?
No, sir.
So same will be with master pusher. Whether he gets admission and whether he not, so that the court cannot compel any parent to get the child to get admission.
I am just saying that.
So you keep on doing whatever you are doing because you are so diligently doing your work. You keep on.
Sir,
whether the child, I cannot instill fortune. I can't direct fortune to be bestowed upon the child. I can pray personally. Also not by judicial order. Even prayer also I have to make personal. Can I record that I am praying before the God that the child will have good fortune? And I hope that.
Sir, I am just saying that.
Sir, the entire effort has been nullified.
Sir,
who is responsible? I am not here to fix that. You may be as innocent as you are, but
I am
nothing
not
can be done.
requesting the court for anything.
I cannot direct the mother to get the admission child admitted because it is for the child of its parents. So I cannot also say that the mother doesn't want to teach the child.
No, I am not saying
Obviously.
that. I am saying that they are cooperating with me to send the child to schools every time. तांग बापा माँ चोमन तार केयर नौचंदी से सब बेले 9टा 9:30 जेतोल को मुतांग टाइम दिए मुतांग सिर्फ छुआ को पठाते तापरे मुता छुआ को स्कूल ने की जाए तार रिटर्न टेस्ट
आपण माने पिलार जेतु से ADHD रे अछि से बयस हेले भलो करिवो. That you must also understand. Seta apanakar nature has created such a situation when parents go on exchanging emails and the child is not getting admission. That is helping him to outgrow his difficulty.
On the Monday, I stayed in front of their house for 1 hour to discuss about.
Sir, those are besides the issue, sir. So I may be having some sympathy for you personally, but as far as legally concerned, I have to stick to my order. I can't change that order right now. I cannot. I should not also.
So will the court, so I just have one request, then can the court request or order me how I should communicate with my wife?
I will not. The petitioner submits that he requests the court to suggest him how he will communicate with his wife.
So
in considered opinion of this court, no court, much less this court, can make such an endeavor regarding suggesting the husband in the marriage the methods of communication he will make with his wife. If the petitioner is intending to read between the lines in the order as directed with paragraph 10, 11, 12 and 15, he should not add anything or subtract anything to the order to interpret in his own way. Rather, the order is to be read plain and simple, to be given plain grammatical meaning.
Sir, I have requested her to come with me, sir.
Sir, I cannot. You are not here to. If you have a right of getting an order from the court, this is not the court also. Suppose the court can issue directions for communications between husband and wife. This is not the place.
Sir, Sir, I am just saying that I have been very transparent and sabu jagar mein kahi ki jaye je please schedule a time to the school.
Despite being requested to conclude his arguments, the petitioner goes on saying that he has been very transparent. What else?
And I have requested multiple times.
He has requested multiple times
to sir comply of the order.
Yes, but no, he has not answered, sir. He will answer that. You have to wait for to listen to him. Like he has been standing and listening to both of us. Yes, Mr. What about your part of compliance in that order?
In that, the opposite party was never informed what which school and when he is taking to the child. Being a father, the mother allowed the child to go with him, but it was never in the knowledge of the mother that where he is taking and when that form was obtained, when that date of examination was fixed. it was never informed to the mother like it. Moreover, on the earlier date, for the opposite party, I had informed that mother has chose a school that is kid. And on the very same day after court, the petitioner went to the school and threatened the staff that you should not admit the child in the kit. And at 5 p.m., the kit staff called the petitioner.
You filed that affidavit?
Yes, my lord. I will write everything.
Sir,
Sir, don't interrupt. So, sir, it a debate competition. No, you must understand, sir.
sir, I want to show.
Sir, you have to show respect to the court procedure and the lawyer also. In response to the submissions made relevant and as well as irrelevant by the petitioner for adjudication of the matter, it is submitted by the learned counsel for the petitioner for the opposite party wife in the marriage mother of the child that the opposite party has been allowing the father to take the child, but she is not aware of the details of the school, or neither she was informed regarding the details of the school where the child is taken. On 2/5/2026, after the court hours, the petitioner went to the which school?
KIT.
KIT International School. KIT International School. Interacted with the staff, and it is alleged he threatened the staff not to take admission, not to give admission to the child. The staff had informed the mother of the child over phone. Yes. What else?
Moreover, an additional affidavit which he has handed over to me. In that, he has taken to 5 schools. He has mentioned also in all the 5 schools, the school has an observation that child is fickle-minded and he is not sitting in a place. It is mentioned in his ID. And it is the only school where in-house ADHD childs are being given therapy. So that is the only school which is best for that kid.
You file that affidavit because at least he is handicapped, not having legal or maybe not trusting lawyers also. So, but at least you have that. So you file that affidavit. It is submitted by the learned counsel for the opposite party that he will file affidavit in response to the additional affidavit filed by the petitioner today and copies of that affidavit is with you or filed in the registry.
It is.
No, don't file it here.
Sir,
it is a paperless code. I can break the glass and insert it. Return कर दिया. The additional affidavit.
Sir, sir, I have one.
Se affidavit कौन वाला?
It has more package.
About भविष्य
I can.
The petitioner submits that he has prepared affidavit. He shall file. आज ही file करिए registry जैसे.
Registry कर दो.
He shall file the said affidavit before the registry, which shall be sent for stamp reporting if it is in order or not. Copy of the affidavit has already been served on the learned counsel for the opposite party. So seeks leave to file response there. Yes.
Sir, I have one request. Sir, when
sir, don't request, sir. It is your right.
Sir,
the courts are here. Sir. We are sitting here only by acting to request.
No,
we have a duty actually. You must understand.
Yes, sir. Sir, I am just.
You are finding it difficult to find your right.
Finding the right.
You right to communicate with your wife.
No,
whether the court should interfere.
No,
yes,
I am saying that. Sir, the allegations made by the
it is not
party.
So you wait for your turn. Competition.
No, sir. Keep
the reply.
Specifically,
be patient to wait for their reply and to which will come on record. The court is not a place for oral exchange of submissions. There has to be basic pleadings. After the basic pleadings, there may be submissions.
After she mentioned that KIT is her preferred choice of school, I requested her that let's go.
So that is besides the issue because now, as on today, order dated 5/2/2026 has not been complied with. You understand what I am saying?
Sir, but
as on date, 5-2 has not, you have sent mail, she says she has not responded. She says where, you are saying that she has not responded. You are not telling.
See,
which person taking?
ମୁଁ ବୁଝିପାରୁଛି
ରେସ୍ପଣ୍ଡ କଲେନି ଆପଣଙ୍କୁ ଦେବା ପାଇଁ। ସେ ଠିକ ସେଟା ତ ମୁଁ ଆପଣ ଯାହା କହୁଛନ୍ତି ମୁଁ ସେୟା କହୁଛି।
ସାର୍ ଆଉ କିଟ୍ କଥା ସ୍ପେସିଫିକାଲି ମୁଁ କହିବାକୁ ଚାହୁଁଛି କି ଯେ ସାର୍ ମୁଁ ଆଗ ସିଏ ଯେତେବେଳେ ଜଣେଇଲେ ଯେ କିଟ୍ ରେ
ସେଟା ସେ ବିଷୟରେ ବର୍ତ୍ତମାନ ଯୁକ୍ତି ହଉନାହିଁ। ଆପଣ ଭାବୁଛନ୍ତି ସେଟା ଆପଣଙ୍କ ଇମାଜିନେସନ ବର୍ତ୍ତମାନ ସେଟା ଗୋଟେ କିଟ୍ ଯୁକ୍ତି ଚାଲିଛି। ବର୍ତ୍ତମାନ କିଟ୍ ବିଷୟରେ କୌଣସି କଥା ସେଇଟା ତାଙ୍କର ସଲ୍ୟୁସନ, ସେଟା ସେ ରିପ୍ଲାଏ ଦେଲା ପରେ ତାପରେ ଆପଣ ଯୁକ୍ତି କରିବେ। ବୁଝିପାରୁଛନ୍ତି କି ସେ ଷ୍ଟେଜ ଆସିନି। ମୁଁ ତାଙ୍କର ଇ ରେକର୍ଡ କେମିତି କରିବି? ସେ ଅବଜେକ୍ଟ କରିନାହାନ୍ତି। ଆପଣଙ୍କର ଗୋଟେ ଆଫିଡେଭିଟ ଦେଇଛନ୍ତି, ଦେ ହାଭ୍ ଏ ରାଇଟ୍ ଟୁ ରେସ୍ପଣ୍ଡ ଟୁ ଦ୍ୟାଟ୍। ୟେସ୍। କେବେ ଆସିଲେ ହବ?
Possible, I will file affidavit on Thursday.
But you try to counsel that if it is possible, then ଆପଣ କିଟ୍ ଚାହୁଁନାହାନ୍ତି।
ମୁଁ ଚାହୁଁଛି
ଆପଣ ଠିକ ଅଛି, ତାହେଲେ ଚାହୁଁଛନ୍ତି କିଟ୍ ରେ ଆପଣଙ୍କର ବର୍ତ୍ତମାନ I think this is not a relationship which has gone that sour. There is lot of hope and there is lot of fear. There are some issues. तो ସେଥିରେ ବର୍ତ୍ତମାନ ପିଲାକୁ ଆଣିକି ଫେର ବର୍ତ୍ତମାନ ପିଲା କୋଉଠି ପଢିବ ସେଟା ଫେର କୋର୍ଟ ଆନ୍ସର କରିବ। ଆପଣ ବୁଝିବା ଦରକାର। ସୋ ସେଇଟାକୁ ଆପଣ ୟୁ ୱାର୍କ ଇଟ୍ ଆଉଟ୍। ଆପଣଙ୍କ 6 ତାରିଖ ସୁବିଧା ହବ ନା କୋଉ ଦିନ ଆପଣ ଆସିପାରିବେ?
ମତେ ପଚାରୁଛନ୍ତି
ଆଜ୍ଞା
5 ଠିକ ଅଛି। 5
ଫାଇଲ କଲେ
ମତେ
କପି ଅଛି actually ସେ he has a point, ସେଟା ହଉଛି problem. He doesn't have assistance. ଆପଣ ସେ 9 ୱିକ୍ ରେ ଦିନ ଠିକ କରନ୍ତୁ।
ସାର୍ ତାହେଲେ 12 ତାରିଖ କରିଦିଅନ୍ତୁ।
ଠିକ ଅଛି। The matter shall be listed on 12th March 2026. ଆପଣ 12th March ରେ ଆଜି ଭଳିଆ ରଖିବେନି ସ୍ପେଶାଲ ବେଞ୍ଚ। ମନେ ରଖନ୍ତୁ ସେଟା ମାନେ ମନେ ରହିଲାନି। I don't blame, but you have to be careful. 12th March 2026, since the petitioner is appearing in person, it will be taken up at 2 p.m. It will be listed, marked at 2 p.m. Yes, next.
My lord, order dated 5-2 will be complied by both the parties.
The order dated, it is still felt apt to reiterate that order dated 5/2/2026 should be complied with the parties, the mother and father of the child,
sir,
regarding admission of the child.
Sir, one thing that was mentioned here that I did not hand over the Aadhaar card, or I had no intention in giving the
No, it has not been mentioned, sir. Whatever has been mentioned and reproduced in the order, that much.
Sir, Aadhaar card.
I'm sure I have not dictated that.
Sir, okay.
Rather, I have said that regarding Aadhaar card, you have handed over the Aadhaar card to the child, then you said that I have handed over a photocopy. In fact, there is no, you see, all this order is different. Order is more nuanced than what I said. The order says the parents shall initiate.
The order, the court observes that petitioner has
there is some difficulty in getting Aadhaar card of the child. The parents shall initiate the process together for obtaining the Aadhaar card and or other identity proof of the child. So now there is a Aadhaar card as it seems.
Yes.
You have handed over a photocopy to the child.
Yes, I will hand it over again.
What the child did with the Aadhaar card, now he can't be asked. We are not supposed to ask also. At least this court is not supposed to ask also.
I will see it again.
Let us see. Whether you give it again or not, that's not the point. That Aadhaar card is there at least. That you have said.
Okay,
Yes, so I have recorded that you have handed over photocopy. Yes. Yes. Next. Mr. Bench. So list up it.
Item 1.
Especially
Yes.
Specialist item 1, 2, and 6. Your Lordship, I'm filing the rejoinder today. I'm serving a copy on the state. Lordship, may kindly.
You have filed in the registry.
I'll file it today in the registry.
Today you have or you will?
Will.
You will. Your name?
A Pradhan, Ananya Pradhan.
Miss Ananya Pradhan for the petitioner. Mr. D.N. Lenka, AG for item 1. And Mr. Lenka and Ms. Pradhan, we have separated the matters so that there will be no confusion, submission and pleadings are concerned.
We have filed counter affidavit in item 6. And in other 2 cases, we are.
No, let us go one by one. They are having difficulty to reproduce. We'll go one by one. Item 1, and I'm concentrating. I am dealing. Item 1.
May I clarify, Your Lordship? I am also filing the rejoinder to their counter in item 6.
Yes, but please appreciate that I am only be dictating orders item wise, so that there is no confusion as far as pleadings is concerned and the status of the exchange of pleadings is concerned. Ananya Pradhan for the petitioner, Mr. D.N. Lenka, AGA for the opposite parties. It is submitted by the learned counsel for the petitioner that she shall file the rejoinder to the counter filed on behalf of the opposite party state, supported by affidavit in the registry today. Copy of the said rejoinder has been served on the learned AG. Not acha. A copy of the rejoinder is served on the learned AG during the proceeding. Stop. Tapar likhiwe, the rejoinder that would be filed shall be taken on record, scanned copy be updated. Yes. Regarding item 1, anything else, Mr. Lenka?
No. Here it is targeted by Honorable Supreme Court that your Lordship must see the order dated 22nd January 26.
Yes.
31st March has been fixed by the Honorable Supreme Court, and status report has to be submitted before the Honorable Supreme Court on 2nd April.
Yes.
So we have only, by this time, 1 month we are having enough.
Yes, you agree for a date, or today you can start arguing. No,
no. May I request your Lordship will also take instruction. We commence in 23rd.
No, not that far. Don't take such long adjournment. Today is February 26th.
Yes.
ଆପଣ ମାର୍ଚ୍ଚ ଯୋଉ ଗୋଟେ ୱିକ୍ ଛାଡି ଦିଅନ୍ତୁ, ଛୁଟି ତ ଅଛି, ଠିକ ଅଛି, ସେଟା ନାହିଁ। ତା ପର ୱିକ୍ କଥା କୁହନ୍ତୁ, 9th ମାର୍ଚ୍ଚ ୱିକ୍ ରେ କୋଉ ଦିନ ଆସିଲେ ହବ? Any day. I mean, no, I'm not saying 9th March. Say week रे कोउ दिन आनले हबो? 8 तारिख रे आसु?
Huge amount is involved.
Huge amount रे आपनकर allowing for doing burglary. Can I cannot. You must understand that it has to withstand judicial scrutiny. If you want to help the other side, you will do that.
No.
They will come and say that, sir, they have burgled my house by taking away the entire money. Can I? You must understand that. This way, there is a subtle way in helping the other side by not following due process of law. Who is getting ultimately the benefit? The other side is getting the benefit. 9th रे आसु अपन जा कहि पे कोन? 9th no 12, 12th, I said 12th. 9th is Monday.
Yes.
देखिबा 12th पे कोन ए परछ देखिबा अपन आज जदी हियरिंग करिवे करंतु नाले
because the matter will be discussed with the
आपनकर huge amount अछि बोले अपन जा नै ता करिवे सेटा जदी कहबे I'll record that, I'll reject it. When huge amount, suppose there is a आपनकर टंकाटे हेले, suppose let us say टंकाटे अपन जा नै ता करि परिबेनी 1000 टंका हेले करि परिबे जदी 10 कोटी हे गेला ताले अपन जा चाहिबे ता करिवे ता घर पसिबे ता जिंस पत्र धरि पळेबे ता प्रॉपर्टी हे कर देबे. But then where is rule of law? Your concern for collecting the due amount should also match with your concern with compliance of law. It is as simple as that.
Consultation will be
Your
Lordship. Your Lordship is calling on 2nd. 12th.
12 ସେଟା ଫିଲା ତ ସେଟା ଏଇଟା 13 କୁ ରଖି ଦେବେ 13 ହେଇ परियो 6 ହେଇ परियो ଆପଣ 6 ମନା କରୁଛନ୍ତି ଆପଣ 23 କହୁଛନ୍ତି ଏତେ ଦୂର ରଖନ୍ତୁନି ହେଲା ନା 6 ରଖିଲେ ଚଳିବ 6 ହଉଛି ନେକ୍ସଟ ୱିକ୍ 13 ସେ ମନା ସେ ଠିକ ଅଛି ଆପଣ on consent of the parties it is submitted by the it is shall I record that huge amount no problem sir for me 1 rupee is important ଆପଣ ପାଇଁ 10 crores important ମୋ ପାଇଁ 1 rupee is also important the person should not return 1 rupee why it's public money
consultation with the
definitely consultation ନାହିଁ ସେ ତ ଶୁଣନ୍ତୁ ସେ ତ ଆଜି ସର୍ଭ କରୁଛନ୍ତି ସେଟା ଆଗରୁ ସର୍ଭ କରିଥାନ୍ତି ହୁଏତ ଆପଣଙ୍କୁ ମୁଁ କହିଥାନ୍ତି ଆର୍ଗ୍ୟୁ କରନ୍ତୁ ବୋଲି ସେ ଆଜି ହିଁ ସର୍ଭ କଲେ ବର୍ତ୍ତମାନ ମୋ ସାମ୍ନାରେ ଆପଣ ଦେଲେ କରିସି and of course if they sought for time to file the rejoinder that is there to be fair with them they also sought for time
and another order you also the past
the learned counsel for the petitioner the opening sentence लिखी दियंतु ठीक है तापर लिखिबे the interim order passed earlier shall continue till the next date 13/3 at 2 PM तक करछन्ते yes 13/3 PM second
Lordship rejoinder.
and also same
already filed
Will file, yeah, Lordship. That
you should have filed
Lordship, I apologize, Lordship.
item 2 लिखिबे miss same appearance it is submitted by the learned counsel that the petitioner seeks further time to file rejoinder to the counter filed by state
he is filing a memo adopting the rejoinder filed in item 6
Yeah.
in both yes
Yes, 1 and 2.
1 and 2
अच्छा it is submitted that one रे ताले one रे भी memo ना counter rejoinder
Memo, your Lordship.
one रे लिखंतु the memo of date has been filed by the petitioner सेटा काटंतुनी पूरा by the learned counsel for the petitioner stating that the counter affidavit filed in WPC 31548 of 2025 counter rejoinder affidavit filed in WPC 31548 of 2025 in response to the counter filed by state shall be adopted in the present application. Copy of the memo is served on the learned AG. अपन rejoinder टा केबे सर्व करले ना कर जाए तो copy of the memo along with the rejoinder is served on the learned AG. The learned AG has liberty to obtain instruction in response to the said rejoinder and file any affidavit if so advised. तापरे जा होला 13 तारिख दिन देखले नहीं पूरे से मेमो फाइल कर ଆପଣ ଆଜି କଣ ମିସ୍ ପ୍ରଧାନ you are not completing any sentence ଯାହା ଆସ୍ତେ ଆସ୍ତେ କହୁଛନ୍ତି ମାନେ କଣ ଯୋଉ huge amount ବୋଲି you are getting defeated
Lordship, sorry. I wanted
Not really.
No, your Lordship, I wanted to clarify that I am filing the rejoinder in item 6. That's why I began.
No, you should have opened the sentence that I am filing memo. That would have, set the tone. Because you said I am filing rejoinder. So I carried that in the item 1 because this confusion actually for these matters have been separated. Yes, do we say order hela तीन memo files करते ना
तीन rejoinder
तीन rejoinder 6 सेटा मिस्टर महंत से चिड़ा होता है
6 तरह rejoinder
नहीं करेक्ट सीरियसली जीवन तीन रे कौन है मिस्टर महंत मिस्टर HK महंत for the petitioner Mr. PK Sahoo for the AC for the opposite party
Item 3 and 4,
Yes.
we have already filed rejoinder. So for item number 5, I
No,
prefer one.
one by one. They are finding it lot of the document में देखो कितने कटाकटी हेगलानी. When you start referring to matters across the list, they find it difficult to correlate and reproduce the order. तीन रे आपण कोन specific कोन तुम आपण का rejoinder file करछंती?
Yes, sir.
Pleadings complete?
Malbu.
Copy serve करछंती?
Malbu.
Yes, Mr. Sahoo, copy serve.
Yes.
You want to obtain instruction to that?
Yes.
Mr. H.K. Mahanto for the Mahanto for the petitioner. You write MOHA.
Some instruction. This case, no preparation places. And what instruction?
No, you will file affidavit then. Because in a contested matter, always leave everything on record.
Yes, yes.
So that you don't file and they don't have to take the plea that आपका करेंगे nine copy nine.
Then I'm fine.
अपन देखो what impression what a matrimonial matter है. See, then एक example देखो without pleadings कले कौन असुविधा हुए. से कौन कहउचंती कौन करूचंती से ताकर से भाउचंती सब जिंस एमती कुआ जाय कोर्ट रे बोली. आप तो सेमती करिवानी.
जेहेतु लास्ट ऑर्डर रे आपनकर गोटे इंस्ट्रक्शन थिला ऑब्जर्विंग दैट फर्स्ट डेट आस्तिला. So I have got a short instruction letter form.
If you want anything,
file affidavit.
No, don't create a situation. They will say that I make a Janu Arjun has a copy. Don't do that. Again, the same thing. Now, Mr. Mahanta started smiling. Mr. Mahanta, maybe that instruction is already contained in the legend or whatever. So,
Directed, I have got a short
correct.
something.
Item 3. The Lord Counsel for the petitioner submits that he has already filed rejoinder in response to the counter filed by the state, and copy has been served. It is submitted by the Lord ASC that he has received up-to-date instruction in the matter, and the matter can be taken up along with on the next date. The matters shall be listed along with the connected matters, along with similar matters, not connected, similar matters on 13/3/2026. Interim order as passed earlier shall continue till the next date. Interim order date for date for Then 4, Mr. Mahanta. Same order, same order. 5.
5 rejoinder not filed within a week.
आपण सब आपण भी सेमती मिस प्रधान को बळे तीटा फाइल करिवे गोटे फाइल करिवेनी सेटा सेही मेथड ना कोन आपण को सब तो फाइल कर देबे.
The only ground is the appeal is pending, but the interim order was rejected. Now,
within 1 week, I'll file.
H.K. Mahanta for the petitioner. Mr. P.K. Sahoo AC for the opposite party. Learned counsel for the petitioner submits that he has received instructions and may be granted 1 week time to file rejoinder to the counter filed by state. Date code. Date code. Accordingly, it is directed the rejoinder shall be filed by
6.
6/3/2026. Copy upon serving copy thereof on the Lord AC for the state. The matter shall be listed along with the similar matters on 13/6/2026. Sorry, 13/3/2026. भूल गया 13/6 के ऊपर. Yes.
Interim order.
Interim order past order shall continue till the next date. Check on the date. 6, Ms. Pradhan, you have already filed rejoinder.
I'm filing it today.
Okay, this is the order should have been passed. एक order actually sorry. Copy serve करचंदी?
Yes, sir.
And along with the other memo. Yes.
Interim to continue.
Interim order shall continue to the next date.
Yes.
Matter shall be listed to Mark that 2 p.m. Yes. 500 ଭୋଟ ଯୋଉଡାକ ଥିଲା ସେଥିରେ ସେଟା ତ ହେଇପାରିବନି ଆଉ କାଲି କରିଦେଲେ ଆଉ ଯୋଉଟା କାଲି କିଛି ହେଇପାରିବନି Yes. You are mentioning any matter? No. Yes. Sorry?
I did not know that your lordship will rise.
So actually, there is a difficulty, technical difficulty.
Your lordship,
I had a bench at 2 p.m. Another bench.